Good afternoon. Welcome to Board of Adjustment. It's 1:30. We've got a quorum. I'm going to call the meeting to order. Okay. Next item is to receive the minutes. Everybody look at that. Okay, we have a motion. You get to
I'll second it.
Motion and a second to receive the minutes. Cast your votes. All right, those are received. Okay. We've got quite a few requests for a continuance, so listen closely to these items, because if you're here on one of those, we're going to take up continuances first. Cindy, you want to read the list?
Okay, we have item number 38, case number 15961, item number 39, case number 15962, item number 40, case number 15968, item number 41, case number 15966, item number 42, case number 15965, item number 44, case number 15963. All those are continued to August 7th per the applicant. Then I have item number 45, case number 15942, item number 46, 15943, item number 47, case number 15945, item number 48, 15946, item number 49, 15947, item number 50, case 15948, item number 51, case number 15949, item number 52, case number 15940, item number 53, case number 15941, and those are all continued until October 2nd, 2025. Item number 54, case number 15935 has been withdrawn. And then on item number 33, it says an application by Just OK Homes LLC, and that should be by Bryce Louders. And it was just an input error on the agenda header, but everything else went out correctly. And that's the end of them.
Okay. We have a motion to continue as read.
Mr. Chair, I'll make a motion to continue all items as read.
I'll second.
Okay, we have a motion and a second. Cast your votes. All right, those items are deferred to August 7 or October 2. Do we have any requests for a continuance from anyone in the audience? I don't have a consent docket, so I think we're ready for number 1.
Item number 1, case number 15903 is a request of Fitzpatrick Properties LLP for a variance to the setback regulations located at 1618 Northeast 16th Terrace.
Come on up. You can use either one. Prefer the middle. Give us your name and address and tell us about your application, please.
Yeah, I'm Leanne Fitzpatrick. The application is for a variance to the setback regulation for a single-family residential property that we're building. This is our first residential property, so we've learned a lot with this first build, but the main contractor that we had, general contractor, was not as experienced as we were told. So we built too close to the curb, and the property is about 80% done. So it would obviously be a huge problem if we couldn't finish the property, and a huge cost, obviously, to move it to what it should be at. It is built about 10 feet too close to the street in accordance with the regular property laws, so we're requesting a variance so that we can move forward and complete the build.
Okay. Nobody signed up on this one. Any questions, comments from the board?
I think had we heard this before? We continued, but I think we did talk about the case. And we were looking maybe for some direction from the
Do you
permitting
guys have
desk.
any questions or?
I've looked at the property. It doesn't appear to be that much of a distance between the other houses as far as where they are to the curb. I believe the easement was a little bit extra on the street, and that kind of made the difference.
Okay.
So, but I'm in favor of issuing. So
Okay.
that, I'd like to make a motion to approve case number 15903 on the basis that it meets the statutory requirement for the variance.
And I'll second.
Was there anybody in the audience wanting to address the board on this application? I don't have anybody signed up. Okay, motion and a second. Cast your votes. You're approved.
Okay, thank you.
Item number 2, case number 15997, is a request of Johnson Associates on behalf of Candace and Dustin Cantrell for a variance to minimum lot size located at 8520 South Council Road.
Good afternoon, Mark Zitzow with Johnson & Associates. Address is 1 Sheridan Avenue. Sarah, could you pull up our exhibit? So this is a bit of a unique project, which is why we're here. Our client owns the platted lot that notes owner's current home. And often when we're at Planning Commission, when somebody is concerned about what would go in their backyard, they're often told, the only way to control it is if you acquire it. And so our client did just that. They purchased the roughly 15 acres behind their home with the intent of maintaining the agricultural use for goats and other livestock and other things that they want to do out there. And they can access that property through their current backyard, which is a bit of a unique situation. So in doing that, they acquire this property with a single-family home that's in good condition. It's not in a state that should be torn down or would need to be torn down, but they have no use for it. So they started with the process of seeking a lot split. Because it's zoned AA, the way that the property is currently configured with the existing tree lines, it falls short of the 5-acre minimum lot size. So we did not think it was appropriate to rezone this property given the balance of it is sought agricultural uses. And most of what's in the area is AA and RA zoning. And so we thought a 2-acre lot size is still appropriate. With that, I'm happy to answer any questions, but we would ask for your approval.
Okay.
And we did receive a letter of support, which was a pleasant surprise.
Anything questions, comments from the board? Nobody signed up on this one. Does anybody want to address the board on this application? Okay, anything from the board?
No, I'm in approval of it. Again, it's 2.12 acres, I think, which is, again, it's on septic, I would assume, or an aerobic system, and that's large enough to handle that. With the existing circumstances and the way it's built, I think it's a good fit for this variance. So with that, I'd like to make a motion to approve case number 15997 on the basis that it meets the statutory requirement for said variance.
And I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you.
Item number 3, case number 15996, is a request of Johnson Associates called Springs Incorporated for a variance to the minimum lot size regulations located generally at 734 Northeast 38th Terrace.
Good afternoon. Again, Mark Zitzow with Johnson & Associates. This is going to look eerily familiar to an application you heard a couple months ago. And I don't remember which commissioner, or may have been Ms. Welch, brought this up, that you can expect to see the owner in between the lots you approved for this variance come back. And sure enough, they received notice of our last application. They watched to see what happened and then contacted us and said, well, we think we need the same thing. So we're here requesting a variance to the minimum lot width in the R1 district. What's shown as a large blue block is platted individual 25-foot wide lots. And so we're asking for the same thing. And I think at that hearing, the commission actually recommended that we take a deeper dive into this and figure out how to fix this in the code. since they are approved legal lots in Oklahoma City that are not able to be constructed on because of the conflict with the zoning code. So with that, happy to answer any questions, but we'd ask for the same approval you gave the adjacent lot owners in yellow.
And I don't have anybody signed up. Does anybody want to address the board on this application? Anything from the board?
The only thing I'd say is that a lot of times where the lots are platted with 25-foot widths, they put two lots together, and I assume that's probably why the rest of the neighborhood is on two lots. This neighborhood and your future plan is to do a development that is going to have much smaller homes, more shotgun style, I'd say.
Right.
And with the other lots in between already being 25 feet, it makes sense to follow suit. So I'm in favor of the variance.
I agree. It would be good to see the development in the
Yeah.
area.
Okay. Ready for a motion?
With that, I'll make a motion to approve case number 15996 on the basis that it meets the statutory requirement for said variance.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you.
Item number 4, case number 15977, is a request of Brandon Boystrom with the Oklahoma City Parks Department for a variance to paving regulations in the DTD-2 in the R1 Single Family and our Scenic River Overlay District located at 400 Southwest 15th Street.
Okay.
Good afternoon, Brandon Boydson, Oklahoma City Parks and Recreation. This application is to seek a variance to the paving type allowed for the current project we have going on the north side of Wiley Post. So this is a continuation to improvements we made in recent years to the south side of the river in Wiley Post Park. We used a permeable pavers instead of standard concrete or asphalt. And so we're moving along with the same kind of concept. We have 2 new parking lots that are going in with this project. One will be the exact same type of pavers that we use on the south side that are also permeable. It'll be right next to the main activity hub. And we also have an overflow area that will be used occasionally for special events and things that is a different type of permeable paving. And so that's what this request is for to seek a variance to use those paver types. And we are coming with the support from the Downtown Design Review. Any questions?
Anything from the board? I don't have anybody signed up on this one. Is there anybody that wants to address the board on this application? Okay.
I'll say I'm in favor of it. It's design elements that were implemented into the plans by the design architect and part of the project, so in continuation of the improvements at Wiley Post Park. Anything, Marcus? No?
Yeah.
With that, I'll make a motion to approve case number 15977 on the basis that it meets the statutory requirement for the said variance.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you for your time.
Item number 5, case number 15995, is a request of Christian Cifuentes for a variance to accessory building regulations and carport standards located in the R1 Single Family District located at 2131 Southwest 20th Street.
Hello. Good afternoon. My name is Christian Cifuentes. This is my wife, Megan. We are here today to request a variance for property 2131 Southwest 20th. I purchased this property in 2022 because of the large carport it had located in the back. The large carport to use as shelter for my motorized things. When I came across this property, it had just what I needed. I was unaware the carport was exceeding zoning standards because of how well built it was. And other properties in the neighborhood have large structures as well. The carport has been built since 2021 from my understanding and has not caused detriment or nuisance of any kind to the neighborhood. So I am here requesting a variance to keep a carport, and I have brought photos to pass around if needed to show the carport. Would you like to see what I brought? Oh, you're, okay.
Yeah, she passed them out, thank you. Questions or comments from the board? Nope, nobody signed up on this one. Does anybody want to address the board on this application?
I do have a couple of questions.
Sure.
And one of them is, why do you even need this variance? Can you not just leave it as is?
I tried. They made me get the variance. We tried many ways.
Like
to-
code enforcement, or do you know who made you get
It's
this?
zoning and what is it?
Did you apply for a building permit?
Yes, that's how it
So
started.
are you going to do something more on this lot?
If you look at the last page, it will show what the idea is. It's basically the carport is behind where the house that I'm wanting to build. It's a carport is what it is.
Right. Okay, so you're wanting to build a new single-family home in front of this.
Yes, and
And you wanna-
they wouldn't,
And you want the variance in order to keep this carport on the site.
they won't give us the permit to build that home because of the
Right.
carport in the back.
And
Yeah.
so what I would say, and one of the reasons why I'm probably not in favor of this, is that what is built is non-conformance. It was never permitted to be built for it originally, and so there's not a lot of legal precedence for why it should stay.
So, okay, it was built, I bought it with that.
Yeah, I understand that you bought it that way, but the people that you bought it from just erected somewhat of a steel building with zero permitting. And so with it not in conformance, to put a single-family home on it and then to have that structure that's not there, to me, it's just too big of an ask to keep the structure.
Okay, and would I be able to maybe make it into the size that you required, what's there already, since it's already built, so I would just take some off to make it the size, would that work?
And again, that would be possible, but you wouldn't need a variance then.
Another
Okay, so
variance?
you wouldn't need a
Oh.
variance today
Oh, okay.
in order to make that into compliance. And so that's why I just feel like I don't think a variance is applicable in this, for this application.
But they are required, so it's basically, okay.
When did you purchase the property?
22.
2022. Yes, it was already built. We had no idea that it was not what the city requires, basically, size-wise.
And on your rendering, is that something that's going to be erected south of the structure?
What was the question?
Is it going to be erected south of the structure? The house?
Oh, yes, it's going to be, yes, towards the south, yes.
So,
I have not gone past this. Did you visit the site?
I did. There's a steel fence all the way around the property. I mean, you can't really see that much of it, but
Yeah, that
it's
fence.
just,
Oh, I'm
it's
sorry.
really large to be, an accessory dwelling or anything else. It just wouldn't.
My question to you is, do you feel like his building would improve where he's at now? Do you feel like,
I think they're going to build a single-family house on this property no matter what, and that would improve the property for sure. It's just, even if with a single-family house, to have that large of an accessory garage on this lot, it could become put into conformance, like I said, if it was built to a standard and the correct size. It just, in its current stance, is a little too large.
and by how far are we exceeding the maximum size, the maximum coverage?
I think it's 1,000 square feet, and this one's 1,900.
almost twice. And again, it wasn't permitted, it's really just a steel, they built it, you know. So you could bring it back into conformance, I think, you know, relatively easy. It just might be a better way, I would feel it'd be a better way to handle the situation that you have. And again, I'm only one vote, and you got 3 other people to convince.
Yeah, the idea is to build what I did in the back, like the last page, build a home in front of it. It's just a large carport in the back, that's it, it's nothing else.
May I just say something? I just wanted to just address.
Get closer to the mic so we can
sorry.
hear you.
Just when he found the property, a big reason is he does have quite a few motorized things that he needed structure, like needed coverage. And because the carport was so large, he would be able to fit everything needed for the coverage. That was a big reason why we purchased the property. And like I said, he was unknowing that it was against zoning standards. So I don't know if there's a way, maybe if the house that's built in front might be smaller, or if there's a way to just be able to keep it the size that it is currently, due to the fact that it is needed that size with the coverage it currently has.
There's many homes around that property that has very similar large carports or buildings, structures.
Anything else from the board? Are we ready for a motion?
I can go either way. I'm torn because I think that the bar is set too low to simply buy something that's not conforming if the idea is that you just get a variance for it. At the same time, I am and have always been sensitive to a variance that the applicant wasn't responsible for. So I'm right there on the line.
Well, I'm concerned about a couple of things. I certainly do understand that you bought the property without knowing or researching things, but this property not only was not permitted, but it's twice the size of what, the changes made to it are twice the size of what's allowed in the code. So very difficult to say everything is okay now regarding that. I'm more inclined to support what Mr. Noble says.
What if we continued it, gave him a chance to look at taking down 900 square feet, making it work?
That's what I was going to ask staff, is would he even need a variance then if he could get it to 1,000 feet?
Sarah Welch, Planning Department. We think he would still need a variance to section 12200.3 because there's no primary structure on the property. So he can't get a permit for the home with a standalone accessory structure.
Okay.
So I think you'd have to at least offer a variance for him to be able to have an accessory structure. Whether or not it meets the size requirements will be a different decision for you. But he will need a variance to allow that to remain while the house is built.
Okay, and I can get behind 1,000 square foot structure and give you, and get a variance for that. What I need to know, I guess, is if we should continue the case and maybe change the application up, or today just give a variance for
Okay.
1,000 square foot.
Well, I think that's a choice that you would have if you want to take a continuance and come back. And see if it works, if you can get the accessory structure size down to 1,000 square feet. I think you'd still have to come back and allow them to give you a variance in order to build your home, and then demolish a portion, I suppose, of your accessory structure, so it's down to 1,000. Or if you really believe you could do that, they could strike one of the variance requests now and approve the other, so.
But at that point, we would have to apply for a whole new variance, or?
No, we'll keep this variance going for you. You probably want to continue, and then we'll try to work it out and come back. at the next meeting.
Let me ask Ms. Welch, I'm certainly empathetic to, to the citizens here before us. Now, is there any way that they could keep that large a structure? If they were to build a house, is there any way to do that, or am I
No,
speaking
you're
out
right.
of turn?
The variant, there's 2 variances requested
Okay.
today. One of them is the allowance to keep the 1,900 square foot accessory structure. And then the second is to allow them to have the standalone accessory structure prior to the house being built on the property. So they cannot get a building permit for their home because they have a standalone accessory structure, and also that accessory structure was not previously permitted and exceeds the 1,000 square foot limit.
So it sounds like a continuance is in order for them to get more information.
I think at this hearing today, if the board is not favorable to allowing a 1,900 square foot accessory structure to remain, it sounds like one option would be that they could continue and see if they can bring that size down to 1,000 square feet. And if that works, we would still bring them back in order to allow the 1,000 square foot maximum structure to remain while the house is built. I think they'll need a variance for that no matter what, unless they were to demolish the accessory structure completely.
Thank you.
Yes.
So it would be my recommendation to continue the application, to work with the staff, and to maybe make a rewrite to it, and then come back.
Okay.
Good.
What's our next one, August 7th?
August 7th.
Is August 7th a good date for you?
August 7th, yeah, that'd be fine, yeah.
Thanks.
And I will say, I'd advise, did you close this at a title company?
When you bought the property originally?
At a title company? Or did you just, like, person to
No,
person?
no, we didn't go through a title company, no.
Okay.
I have a hard time with this. It's just because there's no recourse. The onus and the responsibility is absolutely on him as the buyer, as it is anytime a buyer purchases a piece of property to do their due diligence. But the reality of it is, most homeowners do not go through a process to make sure that there's 100% conformity to the properties that they purchase. And in this particular community, I've not gone by this site physically, but just south of this site, there exists this same thing, presumably just as far out of compliance as it is here. There's a lot of it. And I don't want to veer off course as to speculating why, but there's a lot of that, and there's also a lot of these transactions that take place out of the title company.
There is, on this map,
Title insurance.
Yes.
it has the same R1 behind the property that we have, and there's actual businesses there, so I'm not trying to make a business, I'm just trying to get a,
Yep.
so it just seems a little not fair.
Right, and I totally understand that. I had a hard time to bring something, to allow a variance to something that is so out of compliance is really what it is. And I just looked at it, I mean, from what I could see, it has a hard surface, probably about 1,000 square feet of hard surface, and then the other's built over gravel or whatever. And so that's what I was thinking, you could just bring that back down to the 1,000 foot that's hard surfaced, and then build your structure and the new home.
Would you be okay with that?
Yeah, I'm okay, it doesn't seem like I have other options, so.
And you can
That's-
keep
is
all
that
the
my only
material.
option?
and-
Yeah.
So with that, if you're okay with doing a continuance, work with staff and maybe rewriting the application a little bit, that would be the way I would go.
Okay,
Continuance is better than a no vote.
Yes.
but, I'm sorry?
A continuance on this would be better than a non-approval.
Okay, oh, yeah, I agree with that, yes.
So with that, I'd like to make a continuance to August 7th for case number 15995.
And I'll second.
Okay, we have a motion and a second to continue. Cast your votes. We'll see you on August 7th.
Okay, thank you.
Thank you.
Item number 6, case number 15984, is a request of Sam Moore Architect on behalf of LD Smith Properties for a variance to parking regulations, maneuvering in the street right-of-way in the C3 Commercial District and the HNO Healthy Neighborhoods Overlay District located at 1715 North Lottie Avenue.
Give us your name
Hi,
and
I'm
address.
Sam Moore. I'm representing the owner. This is currently an empty building. They want to remodel it to make it an art gallery. We think that would be an improvement for the neighborhood. There's no room on the property for parking. There is street parking, about a dozen spaces on both sides of the street and in front of the building that's in existence. So we're looking for a variance to not have to have the parking on the property. We are able to create one handicap accessible space on the property. We need a variance for that, for the access, right-of-way access to that space. So that's what we're requesting, and we'd be happy to answer any questions you have.
Nobody signed up on this one. Does anybody want to address the board on this application? Okay, anything from the board?
The only thing I would say is there's quite a few on-street parking spots available within the proximity, and so that's why I would be in
I
favor.
rarely see them in use.
Yep. And that's why I'd be in favor of the variance.
Any other questions, comments? I think we're ready for a motion.
With that, Mr. Chair, I'd like to make a motion to approve case number 15984 on the basis that it meets the statutory requirement for said variance.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you very much.
Item number 7, case number 15998, is a request of Box Law Group, PLLC, on behalf of Bricktown Hospitality LLC for a variance to sign regulations in the DVD Downtown Business District located at 330 Northeast 1st Street.
Good afternoon, David Box, 525 Northwest 11th Street, here on behalf of the applicant, seeking a variance to allow a sign within the right-of-way. This is an application that the design of both the building and all signage went to the Urban Design Commission, received a unanimous approval on the design, and then also they provided a unanimous recommendation for approval on the signage. Sarah, if you would. Oh, boy. So I brought my own exhibit anticipating that. So the interesting thing about this variance is the wall you see that says Tempo along the frontage, and if you flip to the second page, it's zoomed in. The wall is constructed in the right-of-way, which is perfectly acceptable, does not require a variance. When you affix the letters to the wall, it becomes a sign, which then requires a variance. So because we are putting 27 square feet of letters, it becomes a sign requiring a variance. So that's why we're here. We'd ask for your approval. Happy to answer any questions.
Nobody signed up on this one. Does anybody want to address the board on this application? Okay.
And I'm in favor of this variance. I think that the sign code, the rewrite of the sign code is,
There you go.
it maybe has a lot of overreach because they wanted to protect the public, and that's understandable. And I think that this board will see a lot of variances to sign codes.
Well, it is strange that the wall itself is fine in the right-of-way, but you put 27 square feet of letters on, and now we've got to come here.
You get to come here.
Yep, you get to, right.
There's nothing else I'd rather do on Thursday afternoon than spend my time with you fine folk.
Okay.
Anything else?
No. We ready for a motion?
With that, I'd like to make a motion to approve case number 15998 on the basis that it meets the statutory requirement for said variance.
I'll second.
Okay, we have a motion and a second. Cast your votes.
Yeah, hand
And you're approved.
I got one. Oh, sorry.
Item number 8, case number 15999 is Law Group PLLC on behalf of Native Digital LLC for a variance to sign regulations concerning spacing requirement from the HP Historic Preservation Zoned property for a sign located in the I-2 Moderate Industrial District, located at 2306 North Broadway Avenue.
Again, David Box, 525 Northwest 11th Street, here on behalf of the applicant. The applicant is Kelly Lay, who is here with us as well. Undoubtedly, this site looks familiar. We were here previously after your staff issued a permit to allow a billboard on my client's I-2 property. The largest sign company in the Metro, Lamar, under the guise of representing Byron's Liquor Warehouse, appeared before you, seeking to upend the approved sign permit. After multiple hearings and many hours of debate, this body granted the appeal of the various entities, presumably due to a spacing requirement from HP's own property. So this is a case, I think, that is it's the first of its kind. And I say that because your decision created a new methodology as it relates to measurement. I say that because if you recall, we had a permit that was issued by ODOT, that was issued by the City of Oklahoma City, that both the Municipal Counselor's Office as well as Development Services stated, and they stated here at the meeting, that the method of measuring distance that they had historically employed was the sign to the curb right-of-way. And in this instance, that would be the curb right-of-way on the other side of Broadway Avenue. There you go, right around there, which is the grass in front of the fire station. This board disagreed with staff, disagreed with the Municipal Counselor's Office, and granted the appeal. And so we're now here, I think, to seek a compromise in the form of a variance. The variance process is designed as a bit of a relief valve. There are 4 elements you must meet, and the relief valve is when you have a set of unique circumstances. I can't think of a more unique circumstance than having a site that's properly issued by multiple governmental authorities and a board creates a new measurement of methodology. It's fine that that's happened, but that's why we're here. And the reason we're here is there is a 300-foot spacing requirement from billboards to HP-zoned property. Now, the HP-zoned property that we're discussing is, of course, HP-zoned property that underlies Broadway Avenue. So if we think through what was that requirement meant to do, it was meant to protect HP residents, single-family homes in HP neighborhoods. I find it impossible to believe that the intent of a 300-foot spacing requirement would be to shield drivers on an arterial street. Presumably, that's exactly where we intend billboards to be read from, highways, streets, and those things. So if you think through the spirit and intent of that ordinance, by granting the variance before you, in no way do we impair those purposes. Because the closest single-family residential home in HP is perhaps 1,000 feet away. The fire station, although zoned HP, it's important to note, the historic structure was torn down. A new structure was built in the 90s. If you've driven by it, there's nothing historic about it. So the reason for the 300-foot separation is simply not here. Well, that is the classic case of a variance and why the relief valve exists within the code. On its face, we think this is a very simple case for that reason. You told us that we were within 300 feet. If you look at what's within 300 feet, although zoned HP, it is Broadway Avenue, not a place where humans exist outside of their automobiles. Now, I think it's worth talking through very briefly some of the things we heard last time. Now, if you recall, Mr. Hickman was here along with a gentleman named Blake Cody. The first time Mr. Hickman appeared with Blake Cody, him and Mr. Cody were here representing Delmar And if we look to the series of entities that exist that own and control all of the land where Byron's Liquor Warehouse exists, it's two entities. Byron's owns nothing. They are a tenant. PSG is an entity, and Delmar is an entity. Now, both of those entities are the landlord to Byron's. Important to note that through the various legal documents that exist, the Byron family owns all of the entities. So it's Byron that owns and controls all this, and for tax purposes, presumably, has a series of entities that owns the dirt. So you heard Mr. Hickman and Blake Cody first tell you that this will impair Byron's, and on behalf of Delmar, we object because it will be detrimental to our operations. So I've handed you a couple exhibits, the first one being the grant of permanent easement. And I've highlighted, actually my associate Cooper has taken the step to highlight the bottom. And why this is important is this is the rights that my client has that were granted to them by Blake Cody's family and his successors and interests that now apply to Blake Cody. What it says is, grantor agrees that it shall cooperate. Grantor essentially being Delmar in this instance. Shall cooperate with grantee in obtaining any permits, variances, licenses, permissions, governmental approvals, or other authorizations necessary for the construction and operation of the sign as grantor shall from time to time request. Well, of course, we sent a letter demanding that Mr. Cody and his attorney, Bill Hickman, come and cooperate, as they're legally obligated to do, with our request for a variance. Because, of course, standing at this podium begging you to get my permit overturned is the opposite of cooperation. So Mr. Hickman and Blake Cody, realizing that we have perhaps misstep here legally, they took off their Delmar hat. Luckily, they had their PSG hat and their Lamar hat sitting right next to them. So they put those on, did a quick circle, and now we're here on behalf of PSG and Lamar. They continue to tell you how detrimental this would be and what a problem this would be. Which brings me to the last piece. I stand at this podium at least once or twice a week, whether it's before the Board of Adjustment, the City Council, Planning Commission, Urban Design Commission, unfortunately HP Commission, and all the other boards and commissions we have. The one thing I've never done in front of anybody I've ever stood in front of is lied or have been dishonest. The reason being, that little trick may work once, but you've lost all credibility moving forward. So with that in mind, I want you to look at the other lease that I've produced. In the summer of '24, which was last summer, when Lamar, PSG, and no longer Delmar were here telling you what a problem this sign is and how bad this sign is, they were in the background executing a lease for a billboard on the exact piece of dirt that my client has the only legal right to install a billboard. Why would that be? Why would Mr. Hickman and Blake Cody be here telling you that's illegal and you can't do it? And then, in a series of transactions last summer, Lamar executed 2 amendments to leases for 2 signs that already exist, and then a third and brand new lease that, if you turn to the second page of that lease, you'll see a highlight of a parcel number. And then if you look at the county assessor page we handed you, that parcel number is none other, will you go back to the original, the case map? There we go. If you look at the parcel on the county assessor, and you look at your case map, Lamar and Blake Cody and Byron and all the entities other than Delmar, because of course Delmar has a legal obligation to support my client and cooperate and help them, they were working a deal in the back room to authorize the very thing that they told you should not be allowed to be here. Kind of interesting, huh? Unfortunately, or perhaps fortunately, there are limitations within city processes. Luckily, when we get to the courthouse, I have a power of subpoena. And what it revealed was frankly shocking. So, What I'd like you to focus on is integrity, but also the purpose of this variance is simple. You told us that we violated the spacing requirements of 300 feet within HP property. The only HP property within 300 feet as measured from our sign is Broadway Avenue, which is a street. So we would ask that you grant our variance, and I am happy to answer any questions.
Nobody signed up on this one. Does anybody want to address the board on this application? Well, I'm going to call on you next, Bill. Come on. Anything from the board? Okay, Bill, your turn.
My name is William Hickman. I'm here on behalf of Lamar Outdoor Advertising. We submitted a written objection for your consideration. Not even sure really where to start. There's so much of that conversation that had nothing to do with this variance request. It was slinging of mud, which is not uncommon, I guess, I've seen before. I will say just a few things in response. Mr. Box is perfectly aware that the lease that he made reference to and he provided to you was not the correct lease, that there was an error made, and he has received the updated documents correcting that error. That happened without knowledge of the individuals involved with PSG or Byron's, and it was a mistake that Lamar has indicated in the email transmission that they made in the legal description, and that lease has been corrected and changed. Why Mr. Box, with his highest of integrity, chose not to provide that corrected information to you today, I do not know, but that is the facts. Number two, the fact that Lamar and PSG or Byron's extended lease agreements have nothing to do with the price of the tea in China or this variance. They have ongoing business relationships and chose to extend those lease agreements. And again, I have no idea what those have to do with this conversation or with this request for a variance. Number three, Mr. Box's reference to me and/or Mr. Cody, Mr. Blake Cody, and what was said last time we were in front of you, again, has nothing to do with the variance and this request that's here today, but I can assure you that neither I nor Mr. Cody was here at that time on behalf of Delmar. In fact, I'm not here today on behalf of anybody other than Lamar, just to be crystal clear. And interestingly, I guess I wouldn't want to be business partners with Mr. Box or his clients because, in fact, if they are in relationship with Delmar or others, they've actually filed a lawsuit against Delmar, as well as PSG and Byron's. They've also filed a lawsuit to raise and challenge this board's prior decision in their interpretation of the sign code. Lamar is simply here to ensure that the city continues to maintain and uphold the interpretation of its sign code as well as its comprehensive plan, because the city has a proactive or a standard by which you have to require the enforcement of the provisions versus them proactively enforcing it themselves. Now, I think as a starting point, it's also important to remember that we're talking about an 80-foot tall digital back-to-back billboard sign that's going to be seen well into these neighborhoods, well across the expanse of Broadway Extension. Furthermore, this is not a new methodology. The way that the city has done its measurement calculations has been long established and well followed. As I said to you last time, the spacing between billboards is a separate section that specifically says it's measured from the center of the pole. That's subsection G. Spacing from districts also is very clear. And it says from the no billboard shall be constructed. And as we have indicated in our written submission, the billboard is the sign structure or the structure which includes anything above, below, or into the ground. It's not from the center of the pole, which was, I believe, in large part the basis of this body's decision last time and the subject of a pending motion for summary judgment in the district court case, ironically, which then triggered this filing. But I also want to point out, because this was a topic of discussion, I believe one of the board members raised, because within the spacing and measurement language, there are sometimes it says from property, and there are sometimes it says building. Mr. Box is a good lawyer. He's trying to make you think about something that's not actually what's in the code. by saying to you, there is no structure, no single-family structure. That's what's intended, protecting it from a structure. The language that you're to honor says from HP zoned property. And I believe you're the one, maybe, sir, who raised this question because it is different. There's a section that deals with residential buildings, but we're not talking about that language. The operative language says zoned property. Furthermore, your own staff has indicated in Exhibit I, or Exhibit C, the most recent evaluation, that although this site is not located in a design district, there is an ordinance requirement concerning minimum separation between HP zoned property and billboards, HP zoned property. This is found in the new sign regulations. The same requirement was located in the old sign regulations. The applicant needs to provide a detailed site plan showing proposed location and distance from the proposed location to the HP zoned property. Note, this is from Laura Griggs. Zoning lines go to the center of the street right-of-way. So if you grant this variance, you're setting a precedence that any boundaries, any zoned property, whether HP or otherwise, that goes to the center line of the roadway can now be varied and can be done away with. Mr. Box himself has just told you this is a case of first impression. Do you want to be the Board of Adjustment that opens up the floodgates of other lawyers coming up here and saying, well, you granted a variance in that instance from HP because it was just a road? Well, it's intended to go to the center of the road. That was the intent. Ms. Griggs said that herself on the written evaluation of the application for the sign permit marked Exhibit C. But furthermore, this applicant knew about this rezoning, this spacing requirement, because in Exhibit I, their predecessor in interest, Spirit, had applied in 2015 for a sign permit. And the comments at that time from Mr. Mark Magdalena was the sign license required, 25-foot setback, 1,200-foot spacing required, 300-foot spacing required from HP zoning. 2015, it was noted to the sign applicant, the predecessor in interest, to Native, that they had to have 300-foot spacing from HP zoned property. If you look at the statutory conditions, this is not a matter of a subject interpretation like last time. There's reams of case law out there on when it's appropriate to grant a variance. Specific findings that have to be made. The first one, application of the ordinance to the particular piece of property would create an unnecessary hardship. All you have to do is read what the applicant has submitted, and they never talk about the particular piece of property and there being anything that creates a hardship because of this particular piece of property. Rather, they refer to professional staff and their interpretation. That has nothing to do with this particular piece of property. Number two, such conditions are peculiar to the particular piece of property involved. Their opening paragraph talks about how it's zoned I-2, it's next to a railroad, it's by I-235, it's zoned I-2, it's the proper place for a billboard sign. That might all be true, but guess what? There are other requirements in the sign code than just zoning and being along an interstate highway. And one of them is spacing from HP zoned property. There are many, many locations throughout this city where there are I-2 zone properties that don't have a billboard sign on them. Why is that? Because there are other restrictions and conditions that exist that don't allow billboards probably at those locations. And they're also maybe along major interstates. Just because a piece of property is along a major interstate or is zoned I-2 doesn't mean it automatically gets a billboard. It has to meet all of the requirements. And the fact that it's part of Broadway Extension and the fire department building is not historic is irrelevant to this conversation, because this conversation is about HP zoned property unless you want to set a precedence of rewriting the ordinance to change the words of zoned property to being a structure, which I do not think this body has the prerogative or the authority to do. In fact, there was only recently a change to the sign code that Mr. Box and some of his clients participated in. And if they wanted to change this specific provision to be from a historic structure, they could have done it. But the discussion is closed. And your job as a quasi-judicial body is to enforce what's in place and not change the wording to benefit one applicant and create a precedence that is very dangerous, slippery slope. And then I want to just talk about the third one really briefly. The third requirement is relief, if granted, would not cause substantial detriment to the public good or impair the purposes and intent of the ordinance or the comprehensive plan. Now, you might recall from our last conversation, I mentioned to you that the comprehensive plan contains a policy numbered E14. E14 intends for the restriction and reduction in the number of billboard signs. The granting of a variance to allow a billboard sign at a location that otherwise is not legal is completely in opposite and in direct conflict with the intent and spirit of the comprehensive plan. And this is not just me saying this. In fact, we now have a district court ruling here in Oklahoma County. Yes, this is a zoning case, but analogous in the context that Judge Andrews found that rezoning a property to create and allow a billboard sign at a location that otherwise was not allowed, I'm going to read you his words. That found by the court that the non-accessory sign uses as a part of the SPUD 1184, PUD 1750, and SPUD 1127 are illegal and has caused unlawful competition for the plaintiff, Lamar. District Court, journal entry of judgment. The city's actions were unlawful and illegal to rezone property at locations that otherwise would not allow billboard sign to allow billboard sign, being inconsistent and in direct conflict with the comprehensive plan. If you vote to approve this variance, you're doing the exact same thing. And this will be appealed and you will lose. Please save the taxpayers of Oklahoma City the money, because you have precedent from a district court already saying to do something like this would be illegal and unlawful. And it's not Lamar up here trying to say that we don't want competition. We want legal and lawful competition. Happy to answer any questions you might have.
Is there anything from the board? Nobody signed up to speak on this one. Is there anybody that wants to address the board on this application?
Mr. Chair, may I
Your turn again.
respond? Okay.
I believe I was
Marcus, do you want to say
next.
something?
Wait a minute. No.
Okay.
Oh, go ahead. Go ahead.
Dustin Paris, Assistant Municipal Counselor. I'm just going to give you a brief update on the litigation on this matter. After the Board of Adjustment sustained Lamar's appeal, Native Digital appealed that decision to the district court, and that case is now pending. It's set for summary judgment on August 20th to decide whether this board sustaining that appeal was justified or not. This request for a variance is an attempt to undercut the district court process, and I, as an attorney for the city, representing the city and defending your prior decision, recommend that you deny this variance. That's my legal advice to you. To go back on a prior decision would seem arbitrary, and that's not what we want. We don't want to be doing anything that would be arbitrary or capricious. So I urge you to uphold your prior decision and let this play out through the district court process where it belongs and deny this request for a variance.
But before you said it, I've got a question, and I'm not certain, so council will have to weigh in on this. Am I wrong in assuming that the variance is a completely separate matter? I understand that we made a decision on it initially, but we made a decision on an appeal that had they not had not come before us, and had the city not granted an application for the erection of the billboard in the first place, which would have led to the applicant coming and seeking a variance, we would have reviewed on the merits of that case alone. Is this not the same?
Procedurally, it's separate, but substantively, it's the same because you're dealing with the spacing from an HP district. You cannot have a billboard within 300 feet of an HP district per city ordinance. That was the justification for sustaining the last appeal, and that should be your justification for denying this variance.
Well, and that's the heart of the question that I have. Because while I did sustain the last appeal personally, I can only speak for myself, while I did vote to sustain the last appeal, the criteria with which I would look at a variance would be different because the variance application would be coming to me as seeking relief from something that's established. Last time, to simplify it, I believe the way I viewed it, the question that was posed before us was, should this have been granted? I reviewed all the documentation and made the determination that it shouldn't have been granted given the regulations that we had. Now the question has shifted to one of, can you grant this in light of these restrictions?
Two things. That ordinance was passed for a reason. It was part of the new sign code that was approved by council last year. It was a lot of thought and a lot of discussion went into that policy, and 300 feet is the best approach that was agreed upon. So for that reason, you should uphold that. And, you know, my position remains unchanged. I recommend you deny this request for a variance.
This is wild, frankly. I've never seen anything like it. Your analysis, Mr. Uday, is absolutely spot on because we got a permit that was issued by the city. Lamar sought to unwind it. Had the city staff told us, you don't meet spacing requirements, we would have sought the variance we seek today. So to say that by granting a variance that we didn't know we needed in the first instance is seeking to undercut and undermine your ruling is absolutely not accurate. If anything, we're exhausting administrative remedies. What if we get to the courthouse and the court says, well, the board, despite what staff's saying that you met the spacing requirements, said you didn't. Did you seek a variance to see if the board would grant you a variance to that? So to say that we're undercutting is simply absolutely false. This is the process. You just pointed out the exact differences in these cases. The fact that the city attorney's office is standing up here making recommendations to you is absurd.
It's not absurd that I'm giving my client legal advice. I'm allowed to do that.
In an open forum? Are you giving legal advice in an open forum? I thought that happened behind the podium.
Rita, can you give us some help here?
Yes, I can. As you may understand, Dustin Paris is one of the attorneys on the case in district court, and he is here explaining that case and its relevance to these proceedings. So he is, as he's indicated, an attorney in our office, and he, even though he is not assigned to represent the Board of Adjustment, any attorney in our office represents the interest of the city. So you will decide after hearing all of the information presented, just as you would decide on any information that I would provide to you. Any advice that any of us provides to you is just that. It's advice. Whether either of us believe it is absolutely the thing that you should do, you have an obligation because of your role as board members to weigh the facts, to weigh the law as presented, and to make your own determination. We have told you in the staff report, Mr. Paris has told you verbally the position that he recommends. I am not involved in that litigation, and so I am not speaking to litigation. I am speaking only to the portion that is before the Board of Adjustment at this time. So weigh everything that you receive, consider all of the law, apply the law to the facts, and make your own determination about what should go forth from this board.
The only thing before you is a variance, nothing more. A variance to the spacing requirement that was created the last time we were here.
Anything else from the board?
Just a question for you.
Yes, sir.
From the applicant's point of view, a deferral till said case is heard?
No, because again, I mean,
I didn't think so.
So this is a highly unusual set of circumstances, right? In that the city issued us a permit because in the city's determination, we met spacing requirements. Unfortunately, Mr. Voorhees wasn't at that meeting, and perhaps it wouldn't have changed, but we had, a number of people that we had. The city, ODOT, everyone that possibly could have looked at this said, you meet all requirements. Here's your permit from ODOT, and here's your permit from Oklahoma City. We could have never sought a variance because, of course, you can't seek a variance when you meet all the regulations. So it was only after this body said, we don't think you meet it, that it became clear, potentially, that a variance is needed for this sign. So to preserve my client's rights, yes, we filed an appeal. But that doesn't mean we don't have the right to seek a variance from the rule that you told us existed.
Let me speak at this point. You and your client may be well within your rights to seek a variance, but there's a big concern that I have that there's pending litigation concerning a ruling that this board made previously. And I am not in favor of granting a variance at this time with pending litigation. And it's analogous to other situations. Let's take a licensing situation where someone maybe has a criminal offense. It should be deferred until, after that decision is made. So that's my position on it.
And I understand that. And the only thing I would say is that the decision that was made by the board simply told the public what the spacing requirement is, right? Because that was different what the city told us. So the board's decision to undo my client's permit simply said, we're undoing the permit because spacing's not met. Well, the only way to cure spacing, in theory, other than the lawsuit, is we'll seek a variance. That's curing all, or exhausting all your administrative remedies. But I understand where you're coming from, but the nuance is the board created a spacing requirement that no one else had seen. And when you've been pointed out this thing that exists that never existed, one path is a variance. That's why the process is here.
A question, and a question for staff, is that if this variance was granted, it still doesn't give them the right to erect the sign. There's still multiple other avenues that they have to go through to meet the criteria to erect said sign.
No.
Digital billboard.
No, this is it. This is it. And we would dismiss the lawsuit, presumably, and then as Mr. Hickman threatened you, he'll sue you.
Light spillage.
Yeah.
Everything.
We're zoned straight I-2. That's why the permit was issued originally. Everything is met except the spacing requirement that was created by your previous decision.
And I'll say that, in reading the case, and listening, and even the first case, I was the one vote on the other side, and I could see to grant a variance. So I am a little torn because the staff is advising to not, and
Well, I'm not torn at all. I'm confused, and I have no shame in admitting that. I disagree with Mr. Box's idea that we somehow changed the methodology. I think we simply interpreted it and read it. I think that the initial case that came before us on the appeal cited some reasons why they didn't meet the 300-foot requirement. After going through all of the literature, I think that was correct, and so the appeal was in order. I also agree with Mr. Hickman's statement that all of the ownership, that's irrelevant. Is it sketchy? Is it unscrupulous? Yes, but I was not relying on their decision or their expertise in making my determination. I simply relied on the information that was presented to us, which led me to believe that the appeal was warranted. Right now, I struggle because I also think it's irrelevant. Personally, I think it's irrelevant that a lawsuit has taken place in district court. I don't see that as being anything more than Mr. Box and his clients exercising a right to relief, the same rights that Mr. Hickman and his clients exercised initially when they filed the appeal in the first place. And so I think that we're creating a situation that becomes very difficult to digest when we say you don't meet these requirements, because I do agree that there was no need for a variance initially. They were granted a permit, they were going about their day, it was appealed. At the moment that we say you don't meet this 300-foot rule, now they need a variance. So my question would be, sans any type of litigation in district court, say they never filed the lawsuit, but simply came back here, would we not evaluate the merits of the variance on its own?
But the fact of the matter is, they have filed a lawsuit about that very decision. So if they were to prevail in the lawsuit, then they wouldn't need a variance.
That's true, but how could it be considered anything else other than us punishing them for filing a lawsuit by not reviewing this variance case just on the basis of the variance?
That's why I say just defer it until after the litigation is resolved. And then we'll know what the proper interpretation is. But right now, if we make a decision based on, what's presented, we've got this going on in district court, and what if they reverse it?
Well, that goes away. And if the elements necessary for a variance are satisfied and you grant a variance, then the interpretation no longer goes away. In fact, perhaps it cements your interpretation of how it's measured, and you simply granted a variance to the measurement based upon the fact that the spacing is not an HP residence, but it's Broadway Avenue. Defer it.
Anything else? David, Bill, anything else you want to say?
I just want to make one quick note. I meant to say in my opening. As I'm sure you all are aware, the Oklahoma law does not allow many cases to highlight that a self-imposed hardship are not allowed or not grounds for a variance. I'm not sure if it's 3 feet or 100 feet that the spacing required might require, but if the sign location can be slid a few feet, and it's on essentially the same property, the property that looks the same, that only further goes to highlight that this is not a hardship peculiar to this piece of property. This isn't a situation where there's been a highway change that requires a sign to be taller and we need a height elevation variance. This isn't a situation where there's some topography to this piece of land that requires a variance. The variance is supposed to be associated with the particular site, the particular property. And there is nothing peculiar about this piece of land that would substantiate the granting of a variance. Rather, it's a self-imposed financial hardship that they bought a very small, limited, postage stamp-sized easement area that they're trying to work within, and they didn't fully understand or measure the spacing requirements from HP-zoned property and not structure. And so from that perspective, we would urge you to deny this variance regardless of the case situation, although we do agree and respect your opinion on that.
Okay. One more. Go ahead, Dave.
Mr. Chairman. My client rightly points out, if we're looking at legal advice from the city attorney's office, recall that the last time we were here, the city attorney's office stood at that podium and urged you to deny the appeal because of what staff had said. So inconsistency in Dustin's office is what it is, but you're here to vote on a variance.
Okay. Anything else from the board? I think we're ready for a motion. Oh, I'll add one thing. I never consider a vote on a variance as precedent. Every one of them stands on their own. So.
I just have a question for the applicant. Are you guys willing to defer this?
Well, I'm happy to hear what it would gain. The problem is that district court case could take years. My client, this will be her only billboard. She's trying to run her business. She's going up against the biggest operator of billboards, perhaps in the Southeast. A multi-year litigation does nothing but drain money from Kelly's bank account when we think we meet the elements for a variance. So I'm happy to hear what it would solve, but if it's to allow the litigation to go on, That litigation could take years and then appeals.
Anything else?
I'm inclined to grant a variance. I disagree with the idea that that the conditions for granting a variance haven't been met. I think it's plainly articulated in the strip of land just to the west of the subject site that was the source for discussion previously, in the sense that it made sense that that was included into the HP district, but now buildings have been torn down. I believe we had a representative from HP that was here. It did not seem to be a big concern as far as placing a billboard within that threshold that would fall on this median. So I think that if this was the first time that we were considering it, I think that we would grant this request. I think that this has become complex and a little convoluted simply because we made a determination on an appeal, which rightfully so showed that based on the language, it did not meet the criteria to receive a permit. That has nothing to do, in my opinion, with the fact that now a variance is being requested, the hardship has been cited. I look at the hardship as pertaining to this easement because the applicant does not own the entire property, or else I would agree with Mr. Hickman. You could simply slide the location somewhere else. However, the portion of land that they've been granted to place this billboard in, they're restricted. They can't move anywhere else. And so given that, along with the requirement to stay away, to keep a distance away from the HP district, when the portion of the HP district that we're talking about has no historical structures, it makes sense to me that it would be eligible for a variance. That's my thoughts. If there's additional information that we can get, Rita, in terms of the one thing that I am struggling with, we've received advice from municipal council and just trying to find out exactly how that should be weighed. But other than that, that's really the only thing that I have up in the air.
So that is information you received, just as is the staff report, just as is the information both attorneys presented to you. So the application itself says, we'd like to have a variance to the sign regulations. Consider whether this application is the same or different from the one that you decided on previously. Did you get additional information that persuaded you in a different manner than you were persuaded previously? Is this a new case? Is this the same case? But those are all decisions that you have to make and you have to decide, because I don't have a voting toggle over here. But that's what you have before you. Should this happen? And if it should happen and you didn't allow it to happen before, what changed? If it should have happened before and now this is your opportunity to correct it, what is the change? What is the difference between then and now? So those are things to consider, but each of you gets one vote.
Well, I just want to go on the record to say I support the variance. I don't think anything has changed. I think that's important to be on record saying nothing has changed. I think it's two completely different things. I have a 3-year-old son at home. Sometimes he does things without permission. If his older sisters come and say, hey, Malachi came and took something, I address that. Should you have taken it? Should you not have taken it? That's completely different than if he comes and asks me, am I allowed to do this? That's how I see this case. So I'm in favor of the variance.
I'll say mine's the same, as the exact same arguments that Marcus brought up. Is when I read the case originally, that's exactly my feelings and how I thought about it. I think there's been a lot of change. This is just the variance for me, and when you look just at the variance, I'm in favor of granting it because of the existing circumstances that exist today out on the property, and that's why I'd be in favor of it.
Is that a motion?
I want Emily to get her 2 cents. And
I'm still not in favor of it for the reasons that I noted. That's my opinion.
And I understand those totally. It's just, we're supposed to look at this as an individual case for just the variance. So, legal Mike. Anything else?
Not from me. I'm ready to vote,
Okay.
but I got to have a motion.
I'll make a motion.
Okay.
I'll make a motion to approve case number 15999 on the basis that it meets the statutory requirement for said variance.
Second?
Okay, we have a motion and a second. Cast your votes. Approved.
Item number 9, case number 15939 is an application by Terrence Lester to allow home sharing located at 1439 Northwest 34th Street.
Okay.
Hello, my name is Dante DiMaggio. I'm here on behalf of the owners of the property at 1439 Northwest 34th Street. We're looking to get an application for special exemption for home sharing for my buddy who I'm here representing. He is overseas and deployed for the Navy and was hoping to maintain possession of his property when he went overseas. That way he could potentially come back after his deployment and live here in Oklahoma City because he's really enjoyed the time he spent here, and as have I every time I've stopped in. So that being said, I don't have any other stuff here. It's the first time I'm doing this and first property I've been a part of this, just representing him. Happy to answer any questions according to this. The last thing I'll mention is we're looking to have the maximum occupancy at 16 people at one time.
Okay. Nobody signed up to speak on this one. Does anybody want to address the board on this application? Okay. Questions, comments from the board?
Just a couple of things. You said 16?
Correct.
Okay.
And that's at a maximum. Typically, it's between 8 and 16 that are there.
So, I'd just like to go through a few things. Are you currently operating this as an Airbnb or a short-term lease?
Yes, we have paused operations, though.
You have paused operations. When did you pause those operations?
This month.
Okay. You had a code violation in March?
Correct. I think it was delayed via, it went to the mail here in Oklahoma City, and the people I'm representing are in Italy.
Okay. And then another one in June. So you were operating illegally, found out about it, realized what you had to do to go through the application process to get it approved. It's a 4-bedroom.
Correct.
How many baths?
3.
3 full or 2.5?
I believe it's 2.5, actually, yep.
Okay, and I'm just going to say, for precedence for me, on these short-term leases, a lot of times I will go 2 per bedroom. You wanted to go basically 4 per bedroom, and I see your list of how you could get there, but I'm going to want to reduce that number, probably substantially, like in half. I'd like to add a quiet hours change, 9 p.m. to 8 a.m. In the application, they had 10 to
Okay.
8. And then I'd also like to limit the number of vehicles to 5.
Okay.
And no on-street parking. And then this is the first time for this one, so the term would be for a year.
Okay.
And so I'd like to hear from my fellow board members about the number, the maximum number of guests and their thoughts on that. And then yours also, like,
8 makes a lot of sense, not 16.
Mr. Noble, I think that what you've proposed has been consistent with what we have done before, and I would support that.
I'm in agreement.
so if you're in agreement with that,
Yeah, I chatted with the ownership, and we were happy to reduce it for the cars, and happy to reduce their hours or edit the hours. From a occupancy perspective, that would make it very difficult to break even on this property, and would probably have to end up in them selling it at a loss, which is not their intention. They want to keep this as a rental and then obviously come back to live here potentially after deployment. I think that somewhere in between would probably get somewhere closer to where it would be beneficial. And I would like to add too that given the decline in amount of occupants, it would be a decline in the amount of revenue that would be produced from a tourism perspective for the city. At this point, we've had over 500 occupants, which at an average of about 180, I believe, dollars per tourist. That's over $100,000 of revenue for the city. So, you know, I definitely understand how this, you know, where you're coming from and your points. Also want to understand, you know, if that's in terms of, you know, just those numbers specifically or how it affects the community, because the house next door hasn't been foreclosed on for the past 3 years, as far as I'm aware, and we haven't had any issues with the other neighbors. We're close with all of them and have local presence from, you know, the people around us that have been helpful. So that's my perspective on it in terms of benefit, and would like to meet somewhere in the middle between the 16 and the 8 if possible.
and I would like to just, you know, state in fact that obviously someone's looking at the property with 2 code violations called in on you for the sense of the community. The most I can do is 9, and that's 2 per bedroom plus 1. So it's up to
Is
you.
there anything we can do for the property or with the property that would increase that, other than build other
I'm just go
bedrooms?
back to a single-family home in the city of Oklahoma City, having 9 overnight guests. I mean, that's pushing the maximum on any single-family home.
Okay.
That's why I'd go there. This is the first time this has come up, you know, for this license. If it comes back, there's no complaints, you run a really good business, we can then look at it again in 1 year.
Okay, that's our plan.
So you good with the 9?
We're good with that.
Okay.
Sounds like we're ready for a motion.
Did we ask if anyone signed up?
Did I ask? Nobody signed up. Does anybody want to address the board on this application? Sorry, I thought I did. Now we're ready for a motion.
With that, Mr. Chair, I'd like to make a motion to approve case number 15939 on the basis that it meets the statutory requirement for the exception with the following modifications, and that is the maximum number of guests to be 9, quiet hours from 9 p.m. to 8 a.m., maximum number of vehicles to be 5 with no on-street parking for a term of 1 year.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you.
Item number 10, case number 15960 is an application for Maria Ortega to allow home sharing at 3109 South Kentucky Avenue.
Hello, everyone. My name is Lewis, representing for Maria. Property is 3109 South Kentucky Avenue here in Oklahoma City. This is seeking renewal for the BOA. We're seeking a 3-year renewal on this single-family home.
Nobody signed up on this one. Does anybody want to address the board on this application? Okay, questions, comments from the board?
A few questions on this. The renewal's late on this. It expires on May 2nd, and the application was turned in on May 22nd, so 20 days late on on the renewal application, which I think we give them. It's right there
I
at
did
the
come in
end.
person into the city the month prior, April, but there were certain steps additional added onto it, during the applicant, during the process. So,
That's good information. It sounds like you started it in April.
yeah, but either way, I mean, this is the second time I'm applying, but
And
throughout the
it
year.
goes to the term, so that's
Correct.
why I wanted to get that straight first. This is the term that I would want to go with on that. It's a 2-bedroom. How many baths?
One bath, correct.
2-bedroom, 1 bath. You have maximum number of guests to be 6.
Correct.
Do you know what we did the first time? Did we-
4.
Okay.
Go 5.
Yeah, split the middle and go 5.
Okay.
So maximum number of guests to be 5. The quiet hours 9 p.m. to 8 a.m. as listed in the application. Number of cars to be 4, the maximum,
Yeah.
with
yeah,
no
same as
on-street
last year.
parking. And then for a term, I'll say 3 years.
Okay.
Good.
Yeah. All right.
Yeah, that, I'll make a motion to approve case number 15960 on the basis that it meets the statutory requirement for the exception with the following modifications: maximum number of guests to be 5, maximum vehicles to be 4, with a term of 3 years.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Okay. Thank you, guys.
Number 11, case number 15986 is an application by Stephen Roth to allow home sharing located at 2228 Northwest 54th Street.
Yep, Stephen Gote, 2228 Northwest 54th Street. Looking to get an application for special exemption for home sharing.
Okay, nobody signed up on this one. Does anyone want to address the board on this application? Okay, questions, comments?
Just a couple of questions and comments on the application. The maximum number of guests, well, first off, how many beds and baths in this house?
3 bed, 2.5 baths.
Okay. You're requesting 8 guests?
Mm-hmm.
How do you get there, first off, I guess?
Advised by somebody from OKC.
Yeah, but I mean, number of beds, like the rooms. So kings, queens.
2 kings, 1 queen, and a sofa sleep.
Okay, and this is the first time this has also come up. It's a new application. How about we meet at 7?
Okay.
And then the cars, I could see you could fit 2 comfortably. Is the garage available?
Yeah, garage
So you
open.
could put 2 in the drive and 1 in the garage?
Yes,
So
sir.
I'd go
That was the
maximum
plan.
of 3 vehicles?
Yep.
And I'm just put no parking, no on-street parking, but just during quiet hours.
Okay.
So during the day, because of the driveway situation, you could have more, and then the term would be 1 year?
Yeah, and I think I have to come back for
Yes.
renewal, yeah.
And again, I'll tell you, but start it early,
Yep.
so it's timely. Anything else? Nope.
Anything else?
Okay, with that, I'd like to make a motion to approve case number 15986 on the basis that it meets the statutory requirement for the exception with the modification of a maximum number of guests to be 7, quiet hours from 9 p.m. to 8 a.m., 3-car maximum, no parking, no on-street parking during quiet hours, and for a term of 1 year.
I'll second.
Okay, motion and a second. Cast your votes. And you're approved.
Thank you.
Item number 12, case number 15817 is an application by Mr. Doan and to allow home sharing located at 9317 Northwest 118th Terrace.
Is the applicant here on this one? Well, we just put it at the end of the
Yeah.
docket.
Well, I reached out to the applicant several times and didn't get a response because we had continued this one and asked them to stop home sharing, but we still received complaints, so.
Move it to the end, or
Yeah, we'll move to the end. Then
let's see if
make
they
a
show
decision.
up.
Item number 13, case number 15969,
Any left?
is an application by Timothy Beats on behalf of Sion Properties LLC to allow home sharing at 910 North Kate Avenue.
Good afternoon. Timothy Beats, 1213 North Class and Midtown Attorneys. I'm here on behalf of Scion Properties. Interesting with this property, we actually were operating it prior to January 15th. Unfortunately, we can't get that records from the person that was operating it for us. So we started reoperating it 20 days after, our first rental was 20 days after January 15th of the cutoff of 2021 or 2019. So we're here today. We found out that we didn't meet the grandfather clause and we received a citation. So we've filled out the special application and come before this board requesting that it be approved. We have a maximum of 4 guests. We have space for two vehicle parking off street. We think we meet all the requirements. We do have self-imposed restrictions on the guests that they can't have any parties, so there's not really any for quiet hours. You're here to stay. Most of our rentals so far have been from people associated with the medical facilities that are located nearby. We did originally rent this out as long-term housing. However, we found that it would be rented out and then we would go have a tenant that would be there for a year. They'd leave. It'd take us 6-9 months to find somebody else. The property had set vacant. And so once we switched it over to the short-term rental, then it made it a lot easier to operate this property, keep it occupied. And in that neighborhood, especially in the past, it was important to have people there at all times. If they weren't there, the property seemed to get vandalized. And so since we've switched this over, we've had less problems with vagrants and issues at the property, and so we just asked this board to approve our special exception.
Nobody signed up to speak on this one. Does anyone want to address the board on this application? Questions, comments from the board?
Just a couple of questions. You took it over as a new property manager?
I'm not the property manager. His daughter is now the property manager.
Okay. When was that taken over?
It was in January of 2019. We actually signed the new contract with.
So you've been, or she's been property manager since 2019 on this property?
Yes. But unfortunately,
and operating
our first
without a
rental,
license since 2019?
Well, we had been operating it, so we were grandfathered in, but we can't prove that because we switched managers. And we can't get that person to cooperate. I think they have some legal issues.
Okay. And it's a just a 2-bedroom with a single bath. You want a maximum of 4 guests?
Yes.
I want to put the quiet hours into the application, with 9 p.m. to 8 a.m. I want to put maximum number of vehicles to be 2 with no on-street parking, and that parking's on gravel. Is it still on gravel?
Yes.
I think that is in the ordinance that it's supposed to be hard surface, so you might think about making a change there to pave that drive.
I think at one point, I think it has been addressed. I'd have to ask my client, but I think at some point the city allowed us to do that, but I'll check on that.
The term would be 1 year. Anything else?
I'm just curious of when it was leased as a long-term rental?
Prior to becoming Airbnb, I believe it was for years. Since my client purchased it, and I believe that was well over 10 years ago, it was operated as a long-term rental. And then, like I said, shortly before, I forget what the cutoff is, I think it's 2019, 2021, but whenever that grandfather date is, we were operating it as a long-term rental for years prior to that.
So it'll be coming in compliance after this application is approved.
Yes.
Anything else?
I think we're ready for a motion.
Did we ask if anybody?
Does anybody want to address the board on this one? Nobody signed up for it.
So, sorry, as staff, just one quick note. In addition to the special exception, you also need the license for home sharing.
Yes, we'll get that. That's our next step.
With that, Mr. Chair, I'd like to make a motion to approve case number 15969 on the basis that it meets the statutory requirement for said exception with the following modifications: the maximum number of guests to be 4, quiet hours from 9 p.m. to 8 a.m., a maximum of 2 cars, no on-street parking, and for a term of 1 year.
I'll second.
Okay, we've got a motion and a second, so cast your votes. And you're approved.
Thank you.
Item number 14, case number 15967, is an application by Precision Development LLC to allow home sharing located at 923 North Francis Avenue.
I'm Lisa Johnson. I'm with Precision Development for the home share at 923 North Francis Avenue.
Anyone signed up to speak?
Yes, on this one. So let's hear from Joe DiBello.
Good afternoon. My name's Joe DiBello. I'm the resident and owner of 919 North Francis, directly to the south of the property in question. My wife and I built our home and moved our family in during the summer of 2023. That same summer, the newly built property was sold next door, and the current owners furnished and began advertising for short-term rentals. Approximately 6 months later, after multiple incidents of late-night noise, I contacted the city and asked if this property was permitted. I was told it wasn't, and they were issued a violation notice forcing the owner to apply for its permit. In February of 2024, despite protests from myself and another neighbor, they received a 1-year permit. Along with the standard conditions imposed by this board, the homeowner was instructed to provide contact information to the neighboring property owners. However, there were no attempts to provide me or any other neighbors with that information. A few weeks after the board's approval, I contacted Ms. Lakin, who provided me with the homeowner's email address. Over the course of the next year, my wife and I witnessed multiple instances of violations of the conditions of the permit, including parties, late-night noise disturbances, exceeding the 2-car limit, and excessive and illegal street parking, because the opposite side of the street does have a clearly posted no parking sign. On June 30th, as an example, I was awoken at 3 a.m. to the June 30th, 2024, I should say. I was awoken at 3 a.m. to the sound of party guests coming and going next door. Drunken guests were laughing and shouting at each other in the street, off and on for several hours that night. The property also has an outdoor staircase that provides access to the roof. The staircase passes directly in front of my son's bedroom window, approximately 6 feet away. Guests were going up and down the stairs all night, disturbing my son and prompting our dog to bark at the noises throughout the night. At approximately 4:30 a.m., I used the homeowner's email to inform him of the disturbances and asked him to finally comply with his permit condition to provide his phone number so I might have a more timely contact method. We spoke the next day, at which point he apologized for the disturbance, but of course at that point there was nothing much he could do. Since then, there have continued to be occasional parties at the home, and every time I've informed the owner, nothing has been done to address the issue. As you see in the provided photos that I sent in, we've seen catering vans parked in front. We've had food deliveries mistakenly ringing our doorbell well after midnight. The house was used as a staging venue for an entire wedding party in which a hairdresser mistakenly rang our doorbell around 6 a.m. A movie was filmed in the home and on the roof for a week, with all of the shooting occurring in the overnight hours, with upwards of 10 vehicles parked illegally all night long. And on one occasion, guests threw a child's birthday party, complete with a bouncy castle and pony rides in the backyard. When I brought it to the owner's attention, he told me that it was a small family dinner, with guests dropping off gifts and leaving. So I sent him pictures to prove that this was no small gathering. I've provided those for you as well. There were as many as 15 cars parked outside at that point, on the street and on a private slab across the street. He said he would notify the management company. This was approximately 4 p.m. that day. At around 10:30, there were still 3 cars parked outside with guests on the roof talking loudly. The party went on completely as planned, and the management company did nothing to stop it as far as I was able to see. On top of all this, his guests routinely overfill garbage bins and leave them directly next to my front porch. I've asked the owner to have the bins placed in the empty garage, but he has repeatedly refused, claiming the management company doesn't want to disturb the guests when they come to put the trash at the curb. I recommended he ask his guests to manage the bins on trash days, which is a standard practice for many home shares. I've done that myself as a tenant of a home share multiple times. But he refused, claiming he had to defer to the management company, which of course makes no sense since they work for him. So today, after willfully failing to obtain a permit until he was forced to, after repeated violations on the conditions of his permit, and after continuing to operate for over 5 months past its expiration, he's asking for a renewal. So I'm here to vehemently protest the renewal of this permit. This property is currently my only immediate neighboring home, with empty lots directly to my west, south, and east. I just want a real neighbor instead of an ever-changing roster of random strangers. Every time I see new cars in the driveway, I have to mentally prepare myself for the possibility I won't sleep that night. Now, finally, I have reviewed the minutes of this board for the last 18 months since this property received its initial permit. Since that day, out of 309 home share special exception applications, 4 have been denied. In each of those 4 denials, the applicants had the exact same types of historical behavior. So for the sake of consistency, I'm respectfully requesting that this board deny this application. Thank you very much.
Anything from the board?
Just one question. You had mentioned that the applicant had explained to you about a private party. Was it private as in his own party, or was it guests that had?
It was not his own party. As a matter of fact, he said he was out of the city at the time, so he was not able to handle it, so he called the management company.
Okay.
Thank you.
Thank you.
Joe was the only one signed up to speak. Does anybody else want to address the board on this application?
I'd like to.
Okay. Give us your name and address.
Kevin Mears, 2608 Northwest 69th Street, Oklahoma City.
Go ahead.
Am I good?
Yep.
Okay. So we're the property manager, if you want to call it that. We help co-host the property. We came into this, after the owner, Channing, had, started doing the short-term rental thing. He, talked to us about our services. We explained to him at that point that you do require a permit. So at that point is when we went and actually filed the permit. All the houses that we co-host have permits, and that's the first thing I tell a new client is, are you permitted? What's your plan to get permitted? So in that case, as soon as he was aware that he needed a permit to operate this property, he obtained one. So as far as the parties, or what we refer to as parties, I would say of the 14 pictures that were shown, 8 of those were on the same night. That was, it was a Thunder player. He had a 5-year-old niece, and he had 15 people over to the house during the daytime to celebrate the 5-year-old's party. When I reached out to him, as soon as Channing was informed by the neighbor of where the cars were parked, I immediately called that person. I talked to her on the phone. I drove to the property myself. I explained to her that, parties and events are not allowed. Her interpretation was, well, this is just a small thing for a kid. It's not a big raging party, so we thought it was okay. I explained to her it was not okay. She made most of the guests leave immediately. There were cars parked in that lot across the street, but if you drive down the street any given point in the day, you'll see between 5 and 10 cars parked there, and they're not related to this property. So we drove by that lot today on the way here. There was probably 10 cars in that lot, and 923 Francis is not rented right now. So I cannot say how many of those cars were ours versus just normal street traffic, but every single time that we received any sort of picture, story, communication, sometimes it was, most of the time it was things that when we reached out to the guests were not problems. He sent us a picture of 2 cars in the driveway. I was in town, so I was down the street. By the time I got there, 5 minutes later, they were gone. One was an Uber picking up someone to take them to a Thunder game, and one was a DoorDash car. So we cannot be responsible for food delivery and taxi services. So many of these cars, I cannot even tie directly to the property. And every single time that we do have proof that we can tie to the property, we've either driven down there. I mean, Channing drove down last week. The owner said, there's something going on at your property. There's a car backed up to the driveway. Okay, legal, but looks fishy. So Channing was there within 15 minutes. He called the police on the way just in case. They got there. I contacted the guest. The guest said, oh yes, we had a karaoke machine for the 4 of us. We were having a guys trip and we were doing karaoke and the company was coming to pick up their karaoke machine. The police vetted them, talked to them. We did a full walk through the house. There was no damage. There was only 4 people on the property. I say this to say every single time that we have had an incident, a violation, anything outside of the bounds of the permit, we have taken immediate and direct action within minutes to make sure this does not happen again. I mean, if this was a long-term rental, you would still have the occasional issue. And this being a short-term rental doesn't automatically alleviate that. I mean, we can give people full rule sets. And if you look at our rule sets, we went to 2-night minimums 6 months before the city said we had to have 2-night minimums. I mean, we put quiet hours of 10 to 8 before the city said that we had to put quiet hours in our permits. So we voluntarily added restrictions to this property to give us the best chance to not have these incidences. And now on the trash side, these houses are, I cannot walk through the alley between these 2 houses with my hands out. These are 0 lot line houses. And on each side of the house, there's an area where you could potentially put trash cans. There's a gate where we put the trash cans that's not wide enough for the trash cans to go back there, and the gas meter for the property is directly there. Our landscaper literally has to carry his lawnmower sideways over the gas meter to mow the backyard. So we manage plenty of houses in town, and in our experience, when you put trash cans in a garage, you get 3 things. You get a awful smelling garage, and the first thing a guest sees when they open up that garage to your house, their first experience is a garage that smells like death. The second thing is a lot of guests want their personal safety, especially when they're staying downtown. So what they do is they lock the garage door. They put the pins in. So now when our trash person, we have a dedicated trash person that goes to every house and picks up the trash and takes it to the street and takes it back up. That way we can ensure that we're not relying on guests. Because if you rely on a guest, 50% of the time at best will they actually do something. So we pay more than we need to make sure we don't have a trash problem. And in this case, we physically cannot put it in the garage. Guests will lock it out. It'll smell, and then you get bugs. So you get bugs, you get insects, you get rats. It is an absolute mess when you put it in the garage. So what we do is we order multiple trash cans and put them in the only spot we possibly can. Originally, we were requested to move them to the other side of the house. They are actively building 6 homes on that side of the house, and that alley is the access for the construction workers. So every time that we did that, they would get moved off to the side, moved out of the way, knocked over, and then they would not get picked up. So then we had more and more trash, and we would have to hire local crews to come out with flatbeds and pick up our trash at $200 a pop. And we were willing to do that to make this as clean as humanly possible. So those pictures that you're seeing are snapshots in time that align with the story that's trying to be told. That, if you drive by that house right now, that is not what it looks like. That was the trash after 4 guests left on trash day, and it was taken out within hours. So I can find plenty of snapshots for any house that paint a picture any way I want to make it. And in this case, that's what's happening. We are very, very involved. We are local. I mean, my wife and I are local. We have a full-time maintenance staff. We have a full-time housekeeping staff. The same cleaners go to the same house every single time. They tell us if anything's wrong, anything's broken, anything's damaged. I mean, we pay a fortune to make sure that we're doing this right. And when Channing came on with us to have our services, we explained to him the permit process. We explained to him what restrictions we have. It's a very large house. We restricted ourselves to 6 total people that spend the night and no more than double that at any given point in time. And if anyone tells us, or if we see on the cameras, because Channing keeps cameras that record people coming in and out, many times before the neighbors even tell us, we're contacting the guest. Hey, I just saw 15 people go in the house. Get it down to 12, what's going on? We've gotten people banned from Airbnb for not following policies. We have fined people for not following policies. We have done everything we can with every lever that we have available to us on the platform to make sure this doesn't happen. But when the Thunder are in town and you're having championship games, you're going to have people come and they get back at 10 o'clock and they might want to go to the roof deck and have a beer and talk. And that's going to happen sometimes. We do our best to make sure it doesn't happen very often. And even then, when we do find out about it, we take action. So I humbly request you to realize the level of involvement we have to make sure these things do not happen. And the coordination with the neighbor, once we came on, we got the information. He texts Channing immediately, and within minutes, Channing, myself, or our maintenance staff drives by the property. We know the police officer who manages that area. That's his route. Well, I'll call him and I'll say, hey, can you drive by? Are you seeing anything? We try to be as proactive as we possibly can. So I'm not saying we're perfect. We're obviously not. You wouldn't have had any issues if we were absolutely perfect and we met the guest at the home. But aside from that, we've taken every possible precaution that I feel we can take. And you have 12 pictures that were shown from an entire year. And in that year, we had, I want to say, the average month is about 90% full. So you have about 6 guests in your average month times 12 months. So you had 72 guests. And from that, we have 12 pictures, 6 of which were taken at the same night.
Questions, comments from the board?
Yeah, I just want to know, were there any nights that you did not address the issue? You made a statement just a minute ago that, I'll be candid, it didn't sit well with me, and that was that the best you can do is most of the time, that there's going to be some times that people come home, and that's kind of the trade-off that we have. We have a lot of people that come in here and say they're anti-short-term rentals, and they think that we're rubber stamping these, and we try to empower residents and neighbors with tools to make sure that they're still good neighbors even though they're short-term rentals. And I think that the standard is higher. I do think the standard is higher, and I think it's intentional. So I don't think that it's ever the case to say that, well, there's just going to be some times where, Thunder game, people are going to be up at 10 o'clock. The quiet hours are the quiet hours. Now, I completely understand not being able to police. They're humans. We can't make them do what we want them to do. And so I have no expectation out of you that every single person you rent to follows the rules 100% of the time. But I do have the expectation that as soon as you're made aware, either by the cameras or by the neighbors, that you take that serious and say, no, the rules are the rules. 10 o'clock is 10 o'clock. And so, and maybe I misinterpreted what you were saying.
I think I may have misspoke.
Okay.
What I was saying is, people are going to come back. You can give someone a book of laws, and in that moment, they may not follow one. But that doesn't mean we don't still take action. I mean, even though we know that we're going to get a lower review by bothering them, we still do that. I mean, we will still reach out to the guest. We will call the guest. So we have a full-time communications person in addition to myself. So I'll message the guest. She will call the guest. If we don't get a response within 15 to 30 minutes, we drive by the property. So,
Okay. I just want to make sure it's not the case that your neighbor's calling you saying, hey, there's people out here, it's after 10 on the roof, and you're like, that happens sometimes.
No.
That's not
no,
acceptable.
No, sir. And I mean, every time that I've received something from Channing or pictures, and I do apologize, I mean, those are clear violations. I'm not going to stand here and say that they're not. But anytime that we're alerted to something that happens like that, we absolutely take action. And my statement was more meant to say, people have free will and they will do what they want to do, but we still police that. So it's not like we have a certain level of expectation that we're going to allow certain things to happen. It's just that people will do stuff, and if we're not informed or if we don't see it on the camera, there is a small chance that we could miss it. But in every chance that we see it, and we watch those cameras, if we see it, if it's reported by a neighbor, if it's reported by someone else, we've got another couple houses in that area. So, I mean, we don't live that far away, and we're always driving around that area. Anything we hear, see, or are informed about, we take action on every single time.
Yeah. Does anybody have any questions? Okay, come on up, Joe.
I'd just like to address what appear to be a couple of misrepresentations, and one being that this idea that they act immediately anytime anything goes wrong. Just this last month, in June, I actually contacted the owner at about 2 a.m. because I had been woken again by noise, and people coming and going and making noise just outside my window. I texted him. I received no response until the next day. And the response was basically, well, sorry, we have the no parties rule, but it is what it is. I went ahead and filed an Action Center complaint on that. But of course, their hours are, not during the middle of the night, so they're not doing anything. I finally got a response back, and they said, well, we find nothing, because obviously it was the next day, So there's nothing I could do there, short of calling the police, and I don't want to do that. I don't want to call the police for things like that. But the point is, they say they're doing everything, but they're clearly not. And I would just like to reiterate that, again, for all, they may have great intentions of following all the rules, and I don't deny that, but you can't ignore the fact that they have a cumulative period of operation outside of their permit of approximately a year, before they got their first permit and then after their permit expired. And for a company that, says they're trying to follow all the rules, to go that long operating out of their permit, seems to me that there's some holes there that need to be addressed. That's all I have to say. Thank you.
You want to
Say
reply?
on that 2 a.m., he may not have responded to you, but he did send me that message.
Oh, yeah, address the board.
You have to just,
Oh, sorry. That 2 a.m. phone call I did receive, Shannon sent it to me, he was traveling. I did reach out to the guest, I called them, I sent them a message, I did get a response, and they told me that they were headed inside. And at that point, I messaged them in the Airbnb app as well, because we try to keep a lot of conversations there so we can hold them accountable. If you just call someone and tell them, hey, stop doing this, but it's not in the actual Airbnb messages, Airbnb can't take action on that guest. So in addition to calling them and making sure that we're trying to stop them in the moment, we're also building a case so that we can report that guest to Airbnb, and we have all the evidence so they can't do it again. As far as the licensing thing, we don't manage the license for the guest, for the host. We explain to them what the expectation is, we explain to them what the requirements are. We don't take on a house unless it has a license, but the actual maintenance of that license is the responsibility of the homeowner. So, we do send reminders. In this case, I probably should have followed back up. You're right, there could have been a potential hole. I probably should have followed back up on that particular house. But our homeowners they have notifications, they take care of their actual own permit. So I'm not saying that I didn't have culpability or in that by not reminding the homeowner, but at the same time, he was very busy. It slipped, it just literally slipped through the cracks. And as soon as we did it, we never got, notifications or violations, or there was no sticker on the door, but here we are. We're trying to make it right again. So we're not perfect. And to your point, people will do things, and we do our darndest to make sure that we're in full compliance with the restrictions and the rules that we have. We've been superhosts in Airbnb for the last 6 years. We're one of the highest rated hosts in the entire city of Oklahoma City. We take this extremely serious. It's not a fly-by-night thing. We're not here to make money and then jet. We've had the same properties for years and years, and we plan on continuing to do that. And we would not do anything to jeopardize that with the city or the board.
Anything else from the board?
I will just say, I think that you do operate a good business, and it sounds like you do a lot of diligence, and a lot more diligence as we hear on certain other cases. But what I will say is that certain properties, or sometimes existing properties, just can't exist in harmony with the existing neighborhood. And for that reason alone, I think that I will vote to not approve this application.
Understood.
Anything else from the board? I think we're ready for a motion then.
You want me to make the motion? I will make a motion to not approve case number 15967, or deny.
I'll second.
Okay, we have a motion and a second to deny. Cast your votes. Okay, this one's denied.
Item number 15, case number 15972 is an application by Alan Larson of DW Acquisitions LLC to allow home sharing. 2200 Northwest 13th.
Hello, my name is Alan Larson. I'm here on behalf of DW Acquisitions. I'm seeking a one-year application for home sharing license for 2200 Northwest 13th Street. As far as I know, we didn't have any neighbors opposing this location, so I'll go ahead and take questions.
Okay. Nobody has signed up on this one. Does anyone want to address the board on this application? Okay, anything from the board?
Just a couple things on the application.
Sure.
3-bedroom. How many baths?
2 baths.
And the quiet hours, you have 10 to 7. I'd like to make it 9 to 8.
Okay, yeah, no problem.
And maximum number of vehicles that you can park. How many do you think you could park in the driveway and not affecting the sidewalk or the street?
I think we fit up to 3.
Okay. And this is the first time, so a 1-year exception.
Okay.
Good.
Ready for a motion? I'm okay with that.
With that, I'd like to make a motion to approve case number 15972 on the basis that it meets the statutory requirement for a special exception. With the only change to the application, I think, is to add quiet hours from 9 p.m. to 8 a.m. and a maximum number of vehicles to be 3 with no on-street parking.
I'll second.
Okay, there's a motion and a second. Cast your votes. You're approved.
Thank you.
Item number 16, case number 15971 is an application by Alan Larson of DW Acquisitions LLC to allow home sharing at 2207 Northwest 18th Street.
Hello again, my name is Alan Larson. I'm here on behalf of DW Acquisitions, here seeking another 1-year application for home sharing license. Last week I was made aware that many of the neighbors had submitted feedback to the city about the potential use of an Airbnb. I'm glad we got this heads up because my partner and I were able to spend the last few evenings walking the neighborhood and had the chance to speak with about 10 neighbors. We got to hear some of the concerns as well as got to share some of our own. 9 of the 10 neighbors ended up being in favor after speaking with us. And I wanted to thank the people of the neighborhood as several expressed they may be here today in support of the application. I'll go ahead and take questions now.
We got folks.
Okay.
All
I'd
right.
like to hear from them.
Looks like the first one is Sebastian Davis. Oh, wait, get to the microphone and give us your name and address and...
Sebastian Davis, 2215 Northwest 18th Street, Oklahoma City, Ward 6. And my wife and I have lived there for 40-plus years. Long-term residence is a wonderful street. Lots of children, new families moved in. And so we're very glad about that. We live in houses that were built around 1915 and older neighborhood, kept in very good condition. Spent a lot of money on remodeling and renovating. When we first heard about Mr. Larson's application, we were really nervous because we were aware that further down the street, east of us, there was an individual that had bought a house and then carved it up into apartments as single-family residency, and he had done this without any permitting or permission, and is still operating it, although numerous complaints have been made. We were very concerned about the level of city enforcement of the codes. We weren't sure about that. One of our neighbors had come to a previous meeting like this over an exception on that street. That Airbnb on the street, though, has worked out fairly well. I hear there's no complaints. But she has been unable to really determine what level of complaint level is there before you deny an extension or even an application. In this case, we really have no objections to Mr. Larson after seeing what you all are implementing with respect to quiet hours, the number of people that can live there, and the number of cars that it can sustain. We're very confident after hearing some of these decisions that you've made, although we still have a lot of concern about zoning enforcement. Thank you very much.
Okay. Brad?
Good afternoon. My name is Brad Torgerson. I live at 2221 Northwest 18th Street, 2 homes down from the house in question. I'd originally sent in a pretty firm letter of opposition. I think that was after our neighbors had collectively met together, discussed the issues, our common concerns. As my friend and neighbor Sebastian pointed out, we'd had ongoing concerns with the home down the street. We had looked into the developer's history and saw that they had multifamily housing experience, owning apartments experience, things of this nature, and I think it just got us a little bit jumpy. But after Mr. Larson and Mr. Worrell have come to our homes, knocked on our door, we've had conversations. I would say we definitely still have our reservations, and we feel, though, that at least for the time being, if their intent was stated truthfully, they want to use this in order to stage the home, in order to sell the home, and have a resident move in. Our homes are all owner-occupied in the area. That's what we envision for our neighborhood. We would like to have somebody else come in that lives there. If they stay in alignment with that, then we won't have any opposition. So we would be in favor of a 1-year approval with the restrictions you've been discussing up until now. We would like to see that. I'm not aware with how restrictive things could be, but we would want it to be reasonable for them to be able to still rent the place. But as of right now, we would be in support of this as long as they continue with their stated goals and we can stay aligned, stay in communication going forward, and then we'll see how it goes. And that's it. Thank you very much for your time.
And Madeline, looks like Benham.
My name is Madeline Benham. I live at 2112 Northwest 19th. I attended the meeting that these gentlemen both mentioned. I'm not entirely in agreement with the decision that they made. I'm not ever, these days, in favor of more of these short-term rentals. And the reason is that over time, the accumulation of these short-term rentals actually changes the quality of your neighborhood. You no longer have neighbors that you've been exchanging tomatoes with. You no longer know everybody's name. In addition to that kind of qualitative difference, there are some specific problems that occur. One of them is the fire pits that people like to put in their yards now. If you are not used to Oklahoma high winds and high temperatures and drought conditions, you may not realize that some days are not ideal for starting a fire in your backyard. That's happening in our neighborhood with some of these Airbnbs. In addition, we have increasing difficulties with congested streets. I mean, extraordinarily congested streets. There were 10 vehicles parked on my street yesterday. Most of them had nothing to do with Airbnbs. They had to do with people having plumbing problems, some road construction that's being done by the city. But even so, it would behoove us to consider the size of those streets. Those houses were built 100 years ago, and the streets were not built for everyone to own for everyone to own their own car. So those are some difficulties. In addition, I want to mention that there is an Airbnb on that same block, and 2 dogs attacked our dog this week from that Airbnb. No damage done. I'm sure it was just an error. What happened was the people who were staying there kind of weren't familiar with how to latch the gate, and their dogs, you know how dogs just aren't really clear about where their boundaries are, if they can't smell them, and if it's a new place, well, that's happening with some of these Airbnbs because people bring their dogs. The people who are staying in the Airbnb don't carefully walk the yard to check for holes in the fence, but the dogs do. And the dogs are really good at finding a way out. So these are just the kind of concerns that come up with the short-term rentals. I understand that there's a lot of money coming to the city from the short-term rentals, but I think I just want to put in a plea again for those of us who have lived, as in my case, in the same neighborhood for 20 years and have invested a lot of money in updating our houses and improving our houses, and we stand to lose a lot. Unfortunately, my backyard now backs up to a gentleman who I've come to this board about before, who illegally has broken it into multiple apartments. He lies before the board. He causes many, many difficulties because of his behavior, his illegal renting of that house to 6 different families. But I understand there's nothing you can do about people telling lies, but I don't think that we have an adequate number of people to police these things. I don't think that there are enough human beings who work for the city of Oklahoma specifically, whose job specifically is to police these Airbnbs. And I think that that's going to become more and more of a problem. So I respectfully disagree, and I would request that you reject this application. Thank you.
Thank you. All right. That's all I've got signed up. Anybody else want to address the board? You want to go ahead and respond? Alan, go ahead.
Oh, one more.
Sue Hollenbeck, 2231 Northwest 18th Street. So I am a neighbor of the street and the houses right down the street from me. And I think that one of the most important things to remember is just making sure that the applicant follows through on their word of doing what they said that they were going to do. So there was, I think, some miscommunication and probably some things that were said out of haste that were taken not so well amongst the neighbors, but I think that has been rectified in this situation. And so 1 year variance for the STR would be welcome on our end. But we just want to make sure that whatever is stated here that continues to be worked through the next year, that what they state they're going to do is what they are actually going to do, whether that's through the quiet hours, through the cars, and trying to put the house back on the market for the good of the neighborhood. So we certainly don't, or I certainly don't disagree with them wanting the variance for the 1 year period. So thank you.
Okay. Thank you. Alan, you want to respond? Anything else you want to add?
I just wanted to, thank the neighbors that did come here in favor of this. I'm sorry that I wasn't able to speak with everybody that was here, but to address some of the concerns that they did have, the fire pit, the off-street parking. We don't have a fire pit. We probably won't allow one. I just don't see that being a good thing for an Airbnb. And then for the parking, we did spend quite a bit of money on this house rehabbing it. Our initial intentions were to sell it. Last year we put it up for sale. It did not sell over an 8-month period. So we ended up putting some long-term tenants in there. They're getting ready to move out. Our plan is to furnish the house and, yes, throw it up for sale and show it in between the Airbnb showings. So whether it does or does not sell, that's going to be up to the market. We're going to list it aggressively. But we do believe this is the best course of option for the options that we have to try and make everybody happy and the neighborhood happy. And so that's our plan.
Okay. Anything from the board?
Just a few things, and I want to make sure that we encompass everything that you did tell the neighbors. So some of the actions that you said that you would do, could you go through those with us?
Sure. So, and our first option that we would like to do is we would like for the Airbnb application to pass. And then we will rent it out Airbnb, and in between, we'll show the house and we'll list it. So I believe that's the first option. The second option is if we don't pass it, one of the things that the zoning allows for is a boarding house. That's something that we're considering. The third thing that we may consider is midterm rentals. The second and third option are what will pay the most and help pay the bills. We invested a significant amount of money into this property, much more than we originally thought we were going to have to do. But and so with that comes along with paying the bills, right? But those are the options that we presented. This being the first option, the Airbnb being the one we thought would be the best. Let's get some, because the last year when we put this up for sale, we didn't furnish it, and we didn't think it showed as well. And so this time we think putting the furnishing in there, it's going to show a whole lot better. We're investing a significant amount in the furnishing as well to help it show better. And our plan is hopefully we'll get the last of the furniture at the end of this month and to throw it up for sale.
Okay, so on the application, it's a 4-bedroom. How many baths are in this house?
4.
4-bedroom, 4-bath.
Yeah.
And have you been short-term leasing it right now?
We've been doing longer-term leases.
Okay.
So this will be our first attempt at it.
So I want to apply quiet hours, and for me, the standard has always been 9 p.m. to 8 a.m.
That's fair, yes.
The maximum number of vehicles, just looking at, I mean, you say 7, I'm going to say 6.
Yeah, that's fine. I mean, we can fit it a minimum of probably 4, maybe 6 behind the gate. It extends pretty far, and it may not be able to see that. And then we can fit an easily 2, maybe 3 in the front, but 6 is perfect. I mean, there's no real need for that, for more than that, to be honest.
And that's what I was thinking also.
Yeah.
And obviously, the term would be for a year. Have you put any thought to doing a minimum night stay of 2 or more instead of just a single night?
Can you explain to me why you would prefer that?
Sometimes just for consistency purposes, you get a better clientele as far as in harmony with the neighbors.
You know, from the experience that I've seen, most people don't come in and book for just one night anyways, but I wouldn't be opposed to one night because it just allows us to show around the house more.
Yeah, a lot of times the one-night stays are less than, you're asking for 10. That's a lot of guests, and that's kind of where I was going. If I was going to go to 10 guests, I'd probably want a minimum of 2-night stay.
I think that's probably fine. You know, one thing we are concerned about too is we have invested a significant amount of money in the house, and I worry that with a one-night stay that somebody might try and throw a party or something. We don't want to see things happen like some of the other guests have come up here and talked about. I don't want to limit myself to what would happen with the property and making it harder to potentially show it. But from my experience, we haven't had a lot of people on other properties that have tried to go for one night, so yeah. I'm not opposed to that.
Yep. Okay. Well, and truth is, having a 2-night stay is not going to determine whether or not somebody's going to have a party on one night. So it's not guaranteeing that there will not be a party. It's just, maybe it changed the clientele a little bit.
That's true.
And again, that's just something I feel about. I don't know the rest of the board maybe.
And we do try and vet for that. I mean, with Airbnb as an example, they're doing things nowadays where they're reviewing people. You guys probably have heard this from other people, but they're getting reviewed by their hosts, and the hosts are reviewing them. And so before we approve people, we check their background to see if they have good references before allowing them.
Thoughts on that one? The 10 people and 2-night stay, or 9 people and 1?
I'm fine with either of those.
Yeah.
I would support that. I'm just curious, how long have you owned the property?
I'm sorry?
How long have you owned this property?
I think a little over 2 years now.
Thank you.
So I'll leave that up to you on what you want to do, maximum guest-wise.
Maximum guest-wise?
Yeah.
What's your recommendation?
The options that I put out was 2-night stay, 10 guests, 1-night stay, 9 guests.
I would say let's go with the 1-night stay, 9 guests.
Okay. Okay.
Okay. Ready for a
Anything else?
motion?
With that, I will make a motion to approve case number 15971 on the basis that it meets the statutory requirement for a special exception with the following adjustments to the application. Maximum guests to be 9, quiet hours from 9 p.m. to 8 a.m., a maximum number of vehicles to be 6 with no on-street parking for a term of 1 year.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you, and thank you for your service.
Item number 17, case number 15973 is an application by John Kloss and Samantha Kloss to allow home sharing, 4728 Doe Run Drive.
Hello, my name is Anthony Navarro. I'm here on behalf of Samantha and John Claus. She wanted me to extend her apologies. She's has terminal sickness that she's not able to travel for right now. We're here to, I believe, just renew our license for the B&B there on 4728 Doe Run.
Okay, questions or comments from the board? I've got one signed up. Okay. Looks like Sarah King.
Hi, I'm Sarah King. I live at 4724 Doe Run Drive. I don't know who you are, but I'm Sarah. I'm the property owner to the south. Oh, okay, great, awesome. So I met with you all last year, Mr. Noble Uday. Is that Marcus? Is that your last name? Okay. And so I hope that you remember what I did and I sent. But I am here once again to give you an update on the property. And unfortunately, where we're at, I think, is an impasse, which is the document that I provided. Mr. Uday and Mr. Noble, you specifically said the last time that I was here that this home needs to be a part of the environment that we create in our community. And it currently does not meet those standards. And so I'm here to make sure that this is not passed. I did provide quite a few addendums in my letter to provide proof because I was also told from you, Mr. Voorhees?
Close enough, yeah.
Okay. That I should document. So I provided relevant documents. There's more and more pictures that I could provide, but at what point are we going to continue? And so the escalation that you can see, if you read my letter from last year, there was a gun that was pulled on contractors who visited the home. That was a huge point that I can no longer feel comfortable talking to guests. So I did get Mr. Klaus's information, who is the property owner, not this gentleman. But I was under the assumption that there was a property manager that was asked and requested by the board so that I had a person who I could talk to and who was in the state of Oklahoma, because Mr. Klaus, as I still understand it, resides in Texas. So I really just am here to petition and, to be honest, just advocate for my home, my piece of quiet living in my little community in Yukon that is still Oklahoma City taxpayer. So hopefully my addendums, if you have any questions for me, I'd be more than willing to answer.
Anything from the board? She's the only one that signed up. Does anyone else want to address the board on this application? Okay, you want to respond?
Well, actually, I'm just curious with the time that
address the board,
there was a
please.
weapon pulled evidently on one of the at the B&B. I'm not sure if this was a situation where During this time, my wife and I and my son actually were taking care of the B&B. I don't know if this was the night where he went over to check on the pool equipment. It was late at night, and we had some calls about water spillover. Evidently, the guest was unaware for the moment or hadn't seen the text message of them letting us know we were showing up to check on this. If this was the situation, hopefully there was no party. We had one situation where some people did start up a pretty good get-together, evidently. We went through our protocol to stop that, get a hold of the customers, and then called the local authorities. I mean, is there anything we could do to help this situation, or anything we could change, or just maybe get the events to where, I know that Samantha and John, they contact us when there's anything wrong in the houses, that somebody thinks there's someone near there, or water overspill for the pool, whatnot. And each time, I just know they really take care of their property. They have people who show up to do the trash cans, to do the yard, and just to kind of maintain. They do call. They are out of state. They call automatically every time if there's a uproar or anything happening there. And my wife and I usually take care of that.
So are you serving as the property manager for them?
Not at this time, but I'm here as representative, pretty much as a property manager.
Do you know if
we're
there
not
is-
employed with them right now, but anytime they call, it's not a big deal for me to do those things for them. They've taken care of me as far as work goes in the past. So when they do call, it's not, oh, you haven't paid me, I'm not going to go. I go directly there, or we talk to the people. I've actually been to B&B sites in the recent past where we had to actually remove people, from them getting hyphy or whatnot, and they're losing control or destroying property, or just not following the rules to a point where it's causing, an outburst in the community.
Were you involved in any of the situations with the problems at this particular?
The one time we did have a party, I think it was, I don't know, maybe 6 months ago, and some people started having all kinds of cars pull up out there. Samantha called us. We got a hold of the guest. Samantha got a hold of the guest. The guest continued, so we went out there, and we also called the authorities, and we had that guest removed. And so I just feel like if there were points to be made against this property, we probably could have addressed that sooner. And maybe they weren't aware of it or whatnot. But I know Samantha and John, they do take real good care of the community, the surrounding of it. Whether the clientele has allowed that or not, I'm not, all too specific.
Do you know if there are cameras at the property?
They have the doorbell ring, and then they have the pull out back, and we do not really suggest putting cameras where there's pools. There will be children in bikinis or children in swimsuits. That's not something we feel comfortable doing. Usually we'd have a ring camera. They actually have a camera on the front of the garage facing the driveway, and that's the way we were able to monitor whether the traffic was getting to be more than what we are allowed or are comfortable with.
So do you have access to those cameras?
Through Samantha, yes, she gives access to my wife whenever she has, if, say, the Samantha has a call or she looks on her ring and she suspects people coming more, she'll give my wife a view to that to be able to monitor for the little bit and to see how far it goes. Usually you could hear on those things passing by, or whether people are banging or music, and you'd be able to see the parking kind of curves around there, and there's 2 to 3 that could fit in the driveway. It seems like any more than probably 3 cars or 4 would be a bit much for that situation.
So you don't get any notification, you or your wife don't receive any notification?
We don't
unless-
receive the notification specifically on our phone for the app, no, sir. Samantha would receive that, and she's trying to take over. Like I said, she has a terminal illness, so she's trying to save money that would go towards her procedures rather than a management company. It's just in the past, we've helped them. They've been real good to us. And so like I say, if they're in a need, and I don't care if it's 1 in the morning or 9 o'clock at night or 8 in the morning, we take care of them. It's just a matter of getting over there, proving that you're going to take care of the area and keep people away who don't want to act right in your community. Because I do agree that that's not acceptable. And if there was something we could do, we would definitely do that.
And I'll go back to the original application a year ago, or a little over a year ago, and talking to the owner and telling them, what was expected and my expectations of the property. The protester who's here now was concerned just to begin with.
Understandable.
Has a swimming pool in the backyard, nice new house in a single-family neighborhood. Were warned that they would have to operate a business, have a property manager, and be very diligent in their operation. I don't know that one night of the year is a reason to deny the application. So what I've asked Sarah, is there anything else that's happened?
So I text Mr. Klaus every time that there is a noise disturbance. So there's prior texts with noise disturbances, with trash, but the police being called and those guests being evicted was, I thought, the biggest grievance. And to me, considering what the board told me last time, this was a 1 year and they would return, and based on what the board, including similar familiar faces that I see here, we're very disappointed with the lack of property management. A friend is not a property manager, which that's what this situation is. So I would really hate for me to have to continue to document, nothing be done, because as you can see on my videos, on the text message I sent regarding that event, I don't know who this gentleman is. So if he was there, he was not in the front yard when the police were talking to me at the beginning and the end of the event, because I was the initial caller. So, at what point does the board say, we don't want homes that are not a part of the environment, but me as a community member and an owner have to be the property manager? That's not fair to me.
And I believe that also. Full disclosure, we didn't see any videos. We didn't get any of those videos.
I attached them right onto the email.
But
Okay.
We don't get those.
That's
We get
unfortunate.
the written documentation, and that's
Okay.
why I asked if there was something more. And so for you, I'll just say that today, for me, I'm gonna be a denial on this application for short term.
That's understandable. I understand how she feels. And at the same time, as her making the point of a friend is not a management, we started out being paid through them. Those folks having a hard time is why we stopped taking money for the position. If this was to be approved, I can guarantee that I would open up an avenue of communication for John Claus. I don't know whether he felt he was able to since we stopped being paid. I wasn't aware there was multiple incidences. I could have gone there. I don't know whether in their hard times, they just didn't think to reach out, but I can do that. It's not a matter of being paid. It's a matter of just taking care of them. I feel for the community stance, and what's gonna happen here today is gonna happen. But at the same time, I do believe that if we were to continue, that there would be some changes in that area, and I believe there could be other avenues of communication open for this.
I'll just state, I appreciate that sentiment. I feel terrible that she's having some health issues, and prayers that things improve. But I also feel like they were given the benefit of the doubt initially. So when protesters come in here and there is no history, a lot of times the operators, the hosts, get that benefit of there being no history, because we don't want to deny somebody who's not had a chance to prove themselves. In this situation, I do believe they've had a chance to prove themselves, albeit the circumstances are not ideal. What has transpired is a less than pleasant living situation for all of those in close proximity to the property. And so for that reason, I'm going to be a denial on this application.
Anything else from the board?
I just wanted to add that on this case, looking at her pictures, I did reach out to our Oklahoma City just to get a log of how many calls, and they logged one in March and one in May for disturbance calls. Just so you know that they match the picture, the same time of the date.
I will agree with my colleagues. The 1-year trial period is something that, we give people the benefit of the doubt. We try to strike the balance between the impact that it will have on the neighborhoods and yet respect private property rights and people being able to have short-term rentals. They've been given that opportunity, and this one just perhaps has not worked out favorably.
Thank you, ma'am.
With that, then I'd like to make a motion to deny case number 15973.
I'll second.
Okay, motion and a second to deny. Cast your votes. And this one's denied.
Thank you.
Item number 18, case number 15970, is an application by Eric John Cataflue and Nicole Elizabeth Allison Cataflue to allow home sharing located at 1800 Northwest 19th Street.
Hi, yes, Nicole Allison Catalfew. We are here to request a hopefully 3-year extension for our home sharing at 1800 Northwest 19th Street. We do live on the property. We have been operating a successful Airbnb for the past 5 years as a superhost with a 4.97 star rating. We only allow up to 2 guests, and we do have a space in our driveway for the guests to park, so there's nobody parking on the streets. We employ our neighbors across the way to do the cleaning of the property, so we're helping our neighbors to actually gain employment as well. And as far as I know, there haven't been any complaints from any of the neighbors or any that I'm aware of.
Anyone sign up on this one?
Nobody
No?
signed up on this one. Does anyone want to address the board on this application? Questions, comments from the board?
So just a couple of comments. And first,
Sure.
and this is for staff, this is listed as a new application because I believe you're changing the application to
Yes.
allow for 10 nights. But you were currently operating it
Correct.
for less than 10 nights in any single month. This is the operation of, is it 1 or 2 rooms, would you say?
1.
1 room in an existing owner-occupied property.
Correct.
I don't have a problem to go 3 years.
Yeah, I'm okay.
And I don't see any need to make any changes to the application.
Thank you.
Okay, I guess we're ready for a motion.
With that, I'd like to make a motion to approve case number 15970 on the basis that it meets the statutory requirement for a special exception.
I'll second.
Okay, we have a motion and a second. Cast your votes. Yeah. You're approved.
Thank you guys so much.
Item number 19, case number 15975, is an application by Pamela Fleener of Patriot Property Investments to allow home sharing located at 3501 Marston Circle.
Okay, good afternoon. My name is Derek Fleenor. This is my wife, Pamela Fleenor. We are requesting a 1-year approval for this property located at 3501 Marston Circle in Oklahoma City. This would be my wife and I's first Airbnb property. However, we do have other rental properties. We do live close to the residents, and we have already instituted a rule of max of 7 people in the residence. It's configured with a king bed, a queen bed, and then a bunk bed with a double on bottom and a single on top. It is 3 bedroom, 2.5 bath. It's a 2-car garage house, so 2 cars are available to park in the garage and 2 other in the driveway, or it would house 4 cars total. We would institute a no parties rule along with quiet hours of 9 p.m. to 8 a.m. So I'll go ahead and open it up for any questions.
Nobody signed up on this one. Is there anyone that wants to address the board on this application? Okay.
We did receive a written protest I don't know if you have a copy of that or not.
Yeah, and I actually had something to add to that written protest. The letter that we received said any protest or opposition need to be sent in by July 11th.
So it didn't make our packet, but we did receive it by email. I just want you to reach out to them
Okay.
and
Yeah, I'll go have a
contact them.
Conversation.
Yeah, just so they have your contact information and they can get a hold of you.
Yeah, we've had previous conversations with them before, so they do have my number.
Okay. This is the first time this one's come up. I'd like to make an ad for quiet hours, or adjust the quiet hours just for an hour, from 9 p.m. to 8 a.m. I want to put a maximum number of vehicles to be 4 with no on-street parking. The term, again, would be for 1 year. And then the only thing we need to discuss, I guess, is the maximum number of guests. You can sleep 7, 2 plus the 1. So I don't have any problem with that. If any of the other board members have anything on this?
No, I'm good.
Okay, with that, I'd like to make a motion to approve case number 15975 on the basis that it meets the statutory requirement for a special exception, with the maximum number of guests to be 7, quiet hours from 9 p.m. to 8 a.m., a maximum number of cars to be 4 with no on-street parking for a term of 1 year.
I'll second.
Okay, we have a motion and a second. Cast your votes. And you're approved.
Thank you.
Thank you.
Item number 20, case number 15974 is an application by Omega Investments LLC to allow home sharing at 3326 Northwest 16th Street.
Hello, my name is Monica, and I'm here on behalf of Omega Investments, requesting their special exemption for 3326 Northwest 16th.
Nobody signed up on this one. Does anyone want to address the board on this application? Okay.
So are you the property manager?
Well, on behalf of the company, there is no property management.
Okay. On behalf of the owner, this is a renewal. This will come in as a renewal application because it was granted on March 16th of 23, ended March 16th of 24, so it's 3 months late,
Okay.
just for your information.
Okay.
A renewal would give us the idea to maybe adjust the term to more than a year. So for me on this one, the term would be a year.
Okay.
A maximum number of vehicles that you could fit in the drive. I had 3.
Yes.
1 year. It's 1 year and 3 months.
A year and 3 months of expiration.
Oh, yes. 1 year and 3 months out, not a year. Or not 3 months, 24, sorry. But no on-street parking, so a maximum number of vehicles to be 3 with no on-street parking.
There's off-street parking as well.
There is, but I was gonna not allow it because it's on that corner.
Okay, yeah.
So I think they can fit 3 there easy. Quiet hours from 9 p.m. to 8 a.m. So just making a small adjustment to that. And then the number of guests, they have 15 down. Do you know how they get to 15? Like how they could sleep 15 in a 4-bedroom home?
Yes, so there's one king bed, 6 queen, and 1 twin.
6 queen beds in a 4-bedroom home
Yes.
with a king in one of them. So can you tell me what rooms have all these beds in them? So what I'm going to get it to is, for me, I'm not going to allow 15 to stay in this house. How many bedrooms or how many bathrooms are in it?
4.
So 4 bed, 4 bath. Okay. Is it operating as an Airbnb right now?
It is.
So has it been operating for years, like since
Yes, I believe so.
23?
Yeah.
So it's been operating at least a year and 3 months with no license, no special exception?
Not that I'm aware of.
Yeah, no special exception for sure. I don't know about the license. We can check on that. There haven't been any protests.
Don, are you on number 20?
I don't know.
Yeah.
Never mind.
Okay.
Yeah.
I'm on number 20. What about the rest of you? Okay.
Okay. He just said it was on a corner, so I was just trying to,
Oh, okay.
Well, it's,
I gotcha.
yeah.
I'm just making sure.
Well, it's on 16th Street, so you can't park on it anyways, but
Gotcha.
it's a church next door. So I'd like to hear on the guests, on the number of guests. For me, I'd be at 9 as the maximum. Marcus says 8.
Oh, he says 8? Yeah, I'm okay with 8 or 9, and it's consistent with how we've, treated other people, and I think we need to be mindful of that.
Yeah. And again, I think operating it for a year and 3 months without a license is kind of probably why we go to just 2 per bedroom. Your thoughts on that? Would you be okay with 8?
Yeah, I think that's fair.
Okay. And everything else, the cars and the quiet hours, the
Yes.
term?
Yeah.
Did you say 1 year?
1 year.
1 year.
That'll make a motion.
I'm ready.
Okay. Motion to approve case number 15974 on the basis that it meets the statutory requirement for a special exception with a maximum number of guests to be 8, quiet hours from 9 p.m. to 8 a.m., a maximum number of vehicles to be 3, no on-street parking for a term of 1 year.
I'll second.
Okay, we have a motion and a second. Now cast your votes. Pardon? Oh, yeah. Okay, we're going to take a 5-minute break. So, be in recess.
She was approved. She was still standing at the podium.
Yes, you can leave. We approved her, didn't we?
That's what I'm saying. Does she know?
Oh.
I want you all to get more
Okay, thank you for that moment. We're going to go back on the record. Item number 20 was approved. I think we're up to number 21.
Item 21, case number 15979 is an application by Omega Investments LLC to allow home sharing, 1939 Northwest 15th Street.
Half of Omega Investments for the special exemption for 1939 Northwest 15th. But I had a question and was wondering if we could go back to the previous one, only because I got clarification from the owner. And he said that the reason why there is a total of 15 guests to accommodate is because the house really has 3 floors. So it has a basement, and in the basement there is 2 queen beds and a twin bed. And that basement was grandfathered in prior to 2019. And so with those beds downstairs, 1 king bed on the first floor, and on the second floor, 2 bedrooms with 2 queen beds, that is how he's able to accommodate 15 people.
Okay, thank you. But we're on 21.
Okay.
And just to go back on that just for a second, I do remember the first time that application came in, and when we did it, we didn't include the basement. So.
Thank you for the update, but it doesn't change my vote.
Gotcha.
And we're on 21. Okay. Yeah. Any other questions, comments from the board? Nobody signed up to speak on this one. Does anyone want to address the board on this application? Okay, anything from the board?
So on this one, I'd just like to make a little adjustment, and that would be to the quiet hours to start at 9 p.m. and go to 8 a.m.
Okay.
And then I just put a maximum number of vehicles on this of 4 with no on-street parking, and the driveway can handle all 4. The term would be for a year because it, again, it's on the same status as the last one. It's a year and 3 months out.
Okay.
And you had a maximum of 4 guests
Yes.
on this.
Mhm.
So we're all good?
I'm good.
I'd like to make a motion to approve case number 15979 on the basis that it meets the statutory requirement for a special exception with a maximum number of guests to be 4, quiet hours to be 9 p.m. to 8 a.m., a maximum number of vehicles to be 4 with no on-street parking for a term of 1 year.
I'll second.
Okay, we got a motion and a second. Cast your votes. You're approved.
Thank you.
Item number 22, case number 15978 is an application by Omega Investments LLC to allow home sharing at 829 West Eubank Street.
I'm also here representing Omega for 1829 West Eubanks for a special exemption application.
Okay, nobody signed up on this one. Does anyone want to address the board on this application? Okay, anything from the board?
Just the same, I'd like to make the adjustment to the quiet hours from 9 p.m. to 8 a.m. I'll put a maximum number of vehicles on this one to be 4, and for a term of 1 year.
Thank you.
And I think this also has a gravel surface for the parking.
I think, yeah.
So you might talk to your owner about that. I think in the ordinance, it's supposed to be a hard surface.
Okay.
Yeah. Ready for a motion?
Yep.
Okay.
Motion to approve case number 15978 on the basis that it meets the statutory requirement for a special exception with the following adjustments: maximum number of guests to be 6, quiet hours from 9 p.m. to 8 a.m., maximum number of vehicles to be 4 with no on-street parking for a term of 1 year.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you.
Item number 23, case number 15980 is an application by Melissa Atkinson on behalf of McCall & Appleton to allow home sharing located in the R3 Medium Density Residential District located at 4823 Northwest 72nd Street, Unit 4823.
Hello, Chairman and board members. Melissa Atkinson on behalf of McCall & Appleton. This is a renewal for a special exception at 4823 Northwest 72nd Street.
Okay, there's no one signed up to speak on this one. Is there anybody that wants to address the board on this application? Okay.
There was a protest in the packet. You probably saw it. I think it was the same protest that came when it originally was done a year ago. And I do remember that. So it's a 2-bedroom.
Yes,
And we got to 6 guests. Did we approve 6 guests last time also?
you did 5.
5? You're asking for 6 to one more?
Yes.
And you can sleep those?
Yes, we have a queen in both bedrooms and a pull-out hide-a-bed, and we do also have a air mattress, just in case.
I'm looking for quiet hours.
I think I put 10.
10. Would you be okay with 9 p.m. to 8
Perfect.
a.m.?
Yes.
I put a maximum number of cars to be 3, with 2 in the garage, 1 in the street,
Okay.
and for a term of 3 years. So the only question is the guests.
Well, I think we ought to be consistent.
And the reason is the 2 per bedroom and then 1 plus 1. I know that there is a pull-out couch, but I'd be more comfortable with just keeping it at 5.
No problem.
Okay. I'm good.
Okay?
I think we're ready for
We're
a
in agreement
motion.
with that. I will make a motion to approve case number 15980 on the basis that it meets the statutory requirement for a special exception with a maximum number of guests to be 5, quiet hours from 9 p.m. to 8 a.m., a maximum number of vehicles to be 3 with 2 in the garage and 1 on street, and a term of 3 years.
I'll second.
Okay, motion and a second. Cast your votes. You're approved.
All right, thank you very much.
Item number 24, case number 15981 is an application by Cody Gallagly on behalf of Emily Small to allow home sharing located at 2610 Northwest 51st Street.
Hello, Jay Gallagly, 1309 Glenbrook Terrace. This is my wife, Cody Gallagly, same address. We are here for a special exemption for home sharing for Emily Small, on behalf of Emily Small.
Oh, we got one signed up on this one. Yeah, this one. James looks like Sermons? Sermons?
James Sermons. I live at 5113 North Lynn Avenue. My concern is the traffic, potential traffic caused by it. We're already seeing an increase on Lynn Avenue because of the Oak development that's going on. And it may be easy to fix by putting a stop sign on Lynn Avenue at 51st Street, but I did want to express that concern.
Okay. Any questions from the board, comments?
I would say for that, you could just send an email to the Traffic Commission and try to get traction on getting a stop sign at that intersection.
Okay, is that the process?
Mm-hmm.
Okay, I didn't know. Thank you.
Yep.
Okay. Anyone else want to address the board on this application? Anything from the board?
It's a new application. For me, it'd be a term of 1 year. I want to put a maximum number of vehicles to be 2,
That's good.
and then quiet hours from 9 PM to 8 AM. And it's a 2-bedroom, 2-bath, or 1 bath, I don't know, 1.5. But anyways, so the guests would be 4, which is what you have in the application. Anything else? With that, I'd like to make a motion to approve case number 15981 on the basis that it meets the statutory requirement for a special exception. The maximum number of guests to be 4, quiet hours from 9 PM to 8 AM, maximum number of vehicles to be 2, and a term of 1 year.
I'll second.
Okay, we have a motion and a second. Cast your votes. And you're approved.
Thank you.
Thank you.
Item number 25, case number 15988 is an application by Lindsay Payton and William Lindbergh II to allow home sharing located at 1615 Northwest 31st Street.
Hi, I am Lindsay Payton at 1615 Northwest 31st Street. I'm applying for a special exemption for my personal residence. I live at the residence full-time. My husband and I both work from home. We are looking to rent out with Airbnb the above garage apartment that we have in our space. Max people, we had put for 2 guests only. No pets. We do have pets on property, but we do not let our pets interact with the guests, just it's not worth the liability for me. We want to rent it out only on weekends because we do use that space above the garage to work during the work week. Happy to change my quiet hours to start at 9. I think I originally listed at 10, so I'll just put that out there.
Okay, and nobody signed up on this one. Does anyone want to address the board on this application? Okay.
So, on the application, I'm in agreement with the 2 guests. You're the primary resident on property. You'll manage the property. So,
Yeah.
the quiet hours from 9 PM to 8 AM. A maximum of 1 car. You stated in the application too, with no on-street parking. The term for me is maybe a question. I really don't have a problem with the 3-year term because you are on property all the time as the primary resident.
Yeah.
So that's a question I give to the other board members.
I'm okay with that.
I'm okay with that as well because this is their primary residence.
Good.
Yes, I'm also on board, and I just, in anticipation of getting more of these where somebody seeks to do more than 10 days, I'm probably going to be more liberal on these just in general, because the only reason that we're seeing it is because it's being triggered by the new 10-day threshold rule. So,
Yep.
yeah, I have no issue.
Okay, with that, I will make a motion to approve case number 15988 on the basis that it meets the statutory requirement for a special exception with the adjustment to the quiet hours from 9 PM to 8 AM, a maximum number of vehicles to be 1 with no on-street parking for a term of 3 years.
I'll
Thank you.
second.
Sorry.
Oh, sorry. No, I was just saying thank you.
All right, motion and a second. Cast your votes. Now you're approved.
Now I can say thank you.
You're welcome.
Item number 26, case number 15987 is an application by Mark Moody to allow home sharing located at 7712 South Charlotte Drive.
Good afternoon. I'm Mark Moody, 7712 South Charlotte Drive, Oklahoma City, Oklahoma. We're making an application to use our home there as a short-term rental. This home has been in our family since '64, since it was new. My wife and I, our primary residence is in San Antonio, but we have family here, so we're up here about once a month. Our intent, what we've been using the home for in the past couple of years is we just live in it when we're here. But we had made a decision that we would like to, when we're not here, do short-term rental on it because I don't like it to sit vacant. I don't want anybody to kind of get the idea, oh, they're here this week, they'll be gone for 3 weeks, you know. think it would be better if it had some body occupying it when we're not there, so.
Okay. Nobody signed up on this one. Does anyone want to address the board on this application? Okay.
Okay, there were no protests on this. This is the first time this has come up. So the term would be 1 year. I want to look at the number of cars, the maximum number of vehicles would be 4. You fit in the driveway with no on-street parking. I want to put the quiet hours from 9 p.m. to 8 a.m. And so the number of guests, again, will be the only thing we need to discuss. It's a 3-bedroom.
Yes,
How many baths?
2.
3. Would you be willing to go to 7 for the first year? We'll see
That's
how it
fine.
goes. Okay. I'm good with that. Good with that. Yep. All right. With that, I'll make a motion to approve case number 15987 on the basis that it meets the statutory requirement for a special exception with a maximum number of guests to be 7, quiet hours from 9 p.m. to 8 a.m., a maximum number of vehicles to be 4 with no on-street parking for a term of 1 year.
Okay.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you.
Item number 27, case number 15983 is an application by Ashley On and Jacob Gabriel to allow home sharing located at 713 Northwest 33rd Street.
Hi.
Sabrina Adams, I'm a local realtor, and I'm here on behalf of Ashley On for the property at 713 Northwest 33rd Street.
Okay. Nobody signed up on this. Is there anybody that wants to address the board on this application? Okay, anything from the board?
So just a couple of questions on it. This is the first time this has come up. This is the first application for this property. The number of bedrooms,
This one is a 4-bedroom.
So
and
4-bedroom?
It's a larger house, yeah.
4-bedroom, how many bath?
2-bathroom.
Okay. I want to apply the quiet hours from 9 p.m. to 8 a.m.
Yes.
And then the number of vehicles, probably, is the garage available?
The garage is not
Okay.
available.
But you probably put at least 2 behind the gate and then,
Yeah, maybe 3 or 4 was really,
so I 4 is fine,
okay,
4 each, and no on-street parking.
yes.
And the term would be for a year. So the number of guests, you have a 4-bedroom home, you've listed 10 as a max.
What was that?
You've listed 10 as a maximum number.
Okay.
Do you know how they can get to 10 in a 4-bedroom
Well,
home?
so we have 2 king, like, primary suites, and we have a kids' room that has 2 bunk beds, so that's 4 in there. So,
Okay. I'll count to 8.
oh, sorry, no, I'm missing a whole bedroom. No, so we do have 2 kings. I don't actually know what's in that 3rd bedroom for size.
Okay.
It's 1 bed by itself, though.
Would you be willing to go to 9?
Do I have a choice?
There's always choices.
Fine.
You can convince these other people.
No, it's okay. We're fine.
We're full of choices, I promise. But you'd be okay with 9?
Yes.
Okay. Anything else?
I do have the next one on the.
Okay. Good. All right. Well, I will make a motion to approve case number 15983 on the basis that it meets the statutory requirement for a special exception with a maximum number of guests to be 9, quiet hours from 9 p.m. to 8 a.m., a maximum number of vehicles to be 4 with no on-street parking for a term of 1 year.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Item number 28, case number 15982 is an application by Chris On to allow home sharing located at 2517 Northwest 121st Street.
Do you want me to read?
Nobody signed up. Is anybody want to address the board on this application? Okay.
Same questions on this application also.
Okay.
And it's a larger house, but
It's
the
a
term be
five-bedroom.
good for 1 year term. It's the first time this has come up. The maximum number of vehicles, can they use the garage on this one, do you know? No? I'm gonna say 4.
Okay.
And no on-street parking. It's in the back of a cul-de-sac, kind of makes it hard if you try to park in the street. Quiet hours from 9 PM to 8 AM. And so the number of guests, again, we'll have to see how you can sleep 12.
Okay.
Can you tell us how you can get there?
It's the same interior designer, so they do the same. It's 2 king suites. There's usually an extra bedroom that has like a queen and then a kid's room that has 2 beds.
Would you pull the microphone a little bit closer so I can hear you?
Yes, so we do 2
Thank
like
you.
primary suites that has king-size beds. And then the 2 other bedrooms are usually like a queen by itself and then 2 bunk beds for a kid's room. We don't have air mattresses or pull-out couches or any, everybody has a private room and private bed.
So would you consider 11?
I would consider
5.
11.
So it's 2 per bedroom plus 1. It's kind of a standard we like to start, especially on the new applications.
Okay.
Okay, all right. And good with everything else? All right, I'll make a motion to approve case number 15982 on the basis that it meets the statutory requirement for a special exception with a maximum number of guests to be 11, quiet hours from 9 PM to 8 AM, a maximum number of vehicles to be 4 with no on-street parking for a term of 1 year.
I'll second.
Motion and a second. Cast your votes. You're approved.
Thank you.
Item number 29, case number 15976 is an application by Jeremy Howell on behalf of Abby Denton and Hunter Denton to allow home sharing at 75 Northwest 30th Street, Apartment 1.
Okay, I'm Jeremy Howell, 36 West Memorial Road, Oklahoma City. I think it's just a renewal. This is just a 2-bedroom apartment.
I think it's out like, what is it, 3 days, 2 days? You're gonna have to ask for lenience.
I'll let Anna know.
And you know, on this one especially, you want to be timely on these because of the
yeah,
new ordinance and it being an apartment.
New 10% rule, you mean?
Yeah. And I'm okay with it being a 3-year term.
Yeah.
Did anyone sign up on this?
Now, does anyone want to address the board on this application? Okay.
So 3-year term, maximum number of vehicles to be 2, quiet hours 9 PM to 8 AM, and a maximum number of guests to be 4 in the 2-bedroom apartment. Good. Okay. With that, I'd like to make a motion to approve case number 15976 on the basis that it meets a statutory requirement for a special exception. Maximum number of guests to be 4, quiet hours from 9 PM to 8 AM, maximum number of vehicles to be 2, and a term of 3 years.
I'll second.
Okay, we have a motion and a second. Cast your vote. You're approved.
Have a good one.
Item number 30, case number 15985 is an application by Emilio Castillo to allow home sharing located at 1444 Northwest 2nd Street.
Good afternoon. My name is Emilio Castillo. I'm here for 1444 Northwest 2nd Street, looking for a 1-year permit to home share.
Nobody signed up on this one. Is there anybody that wants to address the board on this application?
Okay, well, just a couple of questions. Start with the term. It's a new application, so a 1-year term.
Yes.
Number of vehicles, 2?
2.
Behind that gate, probably get 2 people behind that gate.
Yes.
And no on-street parking. The surface, I believe, is gravel.
It is gravel now.
You probably heard me before, but I believe the ordinance says it has to be hard surface, so
Okay.
look into changing that. quiet hours from 9 PM to 8 AM.
Okay.
And the maximum number of guests. It's a 2-bedroom home? No, it's a 1-bedroom.
It's a 1-bedroom, 1 bath. Yeah, it's a duplex, and we're only using one
One
room. The
side
other
of
one,
it.
I'm storing just equipment, stuff like that. So I'm not.
In the other one,
Yes, so I'm only renting out one.
the one side?
So it's 4 people is what I'm thinking.
How can you get 4 sleeping in there?
Queen bed and a pull-out couch in the living room.
About 3.
3? Okay, that's fine.
Yeah.
Yeah. Yeah, if you agree to 3, then everything else, we can move it.
Sounds good.
Okay. Are we good?
I'm good.
Okay. With that, I'd like to make a motion to approve case number 15985 on the basis that it meets the statutory requirement for a special exception with a maximum number of guests to be 3, quiet hours from 9 PM to 8 AM, a maximum number of vehicles to be 2 with no on-street parking. No on-street parking.
May I ask something? There's a park in north of us. It's Pilot Park. It's closed at the moment. Is that anywhere accessible for anything or no?
Pilot Park.
Yeah, it's a park right north of that address. I don't know if you can see
You
it.
mean to park vehicles
Yeah.
off of there, in that parking lot? Yeah.
Okay, sounds good. Just a question,
Yeah.
because it's vacant.
And then for a term of 1 year.
Okay.
Oh, second. Wake up, second.
Okay, motion and a second, cast your
Motion.
votes.
Thank you.
You're approved.
Item number 31, case number 16001 is an application by Lisa Howard on Simile LLC to allow home sharing at 12713 Gaelic Glen Court. And I was handed a hand-delivered support letter at the beginning of the meeting
You like support letters?
Oh,
by, I'm sorry, I can't read this, by Ted Christenberry.
He's one of the neighbors to the property, so he approves.
Okay.
Good afternoon. My name is Cindy Pichot. I'm an attorney, and I represent Simile LLC. We are asking for a special exception on this property. This is an original application. It's a 3-bedroom, 2-bath. We're looking for 6 guests, and the driveway will accommodate 5 vehicles along the way. Quiet hours are from 9 p.m. to 9 a.m. If anybody shows up with a horse or something like that, we have a neighbor next door who's a co-host, and she could run them off. So we have management very, very close to this property.
got one signed up.
Okay, let's hear from them.
It looks like Marcel Hill?
And
Marcel, sorry.
she's the co-host.
Oh, okay, well, you don't have to sign that, but it's nice to have a
Sel Hill.
form.
My address is 12708 Gaelic Glen Court. I live right next to Ms. Howard. I think she's an amazing neighbor. I had lived there before she came, and the neighbor that lived there before was actually more of a menace than any of her renters have been. She came and fixed up the house amazingly and inspired the rest of us. There's only 7 people in our cul-de-sac, and so we're all very close. We have great communication. Had there been any issues, many people would have come. She's just very kind. She's very respectful of all of our needs and considerations. We have children, we have old people, and so she lets us know when there's new renters, how long they're staying, and that she can contact anyone with issues. Actually, when she asked me to co-host, it was an honor because I'm a stay-at-home mom, I homeschool, and I had already just been keeping an eye like I do on the cul-de-sac, and I was like, okay, yeah, I'll do it. So I greatly approve it.
Very good.
Okay.
Anyone else want to address the board on this application? Questions, comments from the board?
Just on the application, just going through it. You said 5 in the driveway. I would say 3 in the driveway, 2 in the garage.
Yes, sir.
Okay. With no on-street parking because it's a cul-de-sac, and the term would be a year.
Yes, sir.
Okay. Good.
Yep, I'm good.
All right. With that, I'd like to make a motion to approve case number 16001 on the basis that it meets the statutory requirement for special exception And how many have I done today?
It's been a long day.
With the maximum number of guests to be 6, quiet hours from 9 p.m. to 9 a.m. per the application, 5 car maximum, 2 in the garage, 2 in the drive, no on-street parking for a term of 1 year.
I'll second.
Motion and a second. Cast your votes. You're approved.
Thank you.
Item number 32, case number 15989 is an application by Just OK Homes LLC to allow home sharing at 2244 Northwest 20th Street.
Hi, I'm Christina Clifford, the sole owner of Just OK Homes, looking for a special exemption for 2244 Northwest 20th, affectionately known in our family as Haven. It's been a labor of love fixing up this property and a bigger labor on our bank account. And by the time we got it all fixed up, put it on the market did what it does, and it has not sold. So that's kind of also what's difficult about having a 2-bedroom, 1-bath. But more recently, my mother-in-law has decided that she will be moving into the property once she finishes her chemo treatments, but that will be quite some time away. So we would like to continue with our request for the special exemption so that we can try to recoup, but also just try to pay the mortgage bills so that we can keep this property so that she has a place to move into when she beats it. So yes, that's where we're at.
Nobody signed up on this one. Does anyone want to address the board on this application? Okay.
So the only thing I would want to do is put a maximum number of vehicles to be 2 with no on-street parking.
Yeah, so the driveway is actually shared with my
The neighbor?
door neighbor. There's not a dividing line, but it's very clear you can park, because we do park 2 vehicles side by side in tandem, but you'd have to, for people parking on our half of it, it would be 1 pull in, 1 right behind it. And technically, you could probably fit 3. I just wouldn't recommend it, and I care about my neighbor and I care about the house, so
2.
I'm good sticking with 2.
Okay.
Same as why there's 4 guest max.
Okay. Any other questions?
No.
With that, I will make a motion to approve case number 15989 on the basis that it meets the statutory requirement for a special exception with a maximum number of guests to be 4, quiet hours from 9 p.m. to 9 a.m., maximum number of vehicles to be 2 with no on-street parking for a term of 1 year.
I have one question. Are quiet hours from 9 p.m. to 8 a.m.?
9 a.m. That's what's listed in the application, so that's why
Okay, you
I
just
went
want to
with
go,
it.
okay, I just wanted to clarify. I'll second.
Okay. Motion and a second. Cast your votes. You're approved.
Thank you. Thank you very much.
Item number 33 is case number 15991 is an application by Bryce Louders to allow home sharing located at 2319 Northwest 17th Street.
No applicant.
The
Let's push
applicant
it.
here?
He got tired of it.
Let's just stick it at the bottom with the other one. And
Item number 34, case number 15993 is an application by Chris Cooper of Team Realty Investments LLC to allow home sharing at 3308 Rock Creek Road.
Hi, Chris Cooper, 6109 Sudbury Drive. And this is an application for a renewal for the property listed 3308 West Rock Creek Road.
Okay, 34. We have people signed up on this one. Let me go to the folks that want to speak. Looks like Marcia Swift.
I'm Marcia Swift. I live at 3300 West Rock Creek Road. We've been there for 48 years, and so what's interesting about our situation, these 2 Airbnbs are next door to each other.
And I want you to be sure to, on this application, to just do it for this property. 'Cause,
Just
I mean,
do one at a time?
Yes.
Yeah, please.
Okay. So I'm going to go ahead and just jump to the neighbor who lives across the street who wrote. His name is Nathaniel Wilson. His father-in-law owns the property. And so he really sees what's going on a lot more than what we do. And he just mentioned in his letter to you that there's been multiple instances with emergencies that it's been obstructed. So we are concerned about emergency vehicles coming into the property. And then he mentioned noise disturbance. He mentions that he can feel the bass in his home located across the street at such high volumes. Substance use, he observed drug use during events, odors being noticeable from his home even with all the windows are shut. Neighborhood respect. He said tenants have demonstrated a lack of consideration for neighborhood, resulting in trash being left behind, which he's had to clean up. Parking issues, he mentions during events, the vehicle has been led to cars lining our street, even blocking his access. He can't get out of his driveway. And so he has a wife and 3 children, and he doesn't let them play outside in the front because of our vehicles that are there commonly, and their ages are from 1 to 9. We have no sidewalks, so children have to be in the street to ride a bicycle or tricycle or whatever, and you never see them. And so I'm speaking for Nathaniel, and that's, but basically, since this is in the Quail Creek property, Mr. Cooper keeps his properties pristine, and we've liked that. But in his Airbnb, it just says that this neighborhood, tranquility, access, intelligent homes, ideal retreat for families, professionals, travelers seeking both comfort and convenience. And then it goes on, peaceful and safe community. This quiet residence area boasts low traffic, relaxed environment, making it perfect for morning jogs, evening strolls, or bike rides. The community is friendly, the streets are well lit for safety. With all the cars that we have coming in and out, we don't feel safe. That's our biggest concern. And on the next case, I have pictures and things to verify the issues that we have, but I'm speaking mainly for the gentleman who lives across the street with his wife and 3 children. He could not be here today.
Anything more? Okay. Next, Don Swift.
My name is Don Swift. I'm Marcia's husband, and we've lived in our home for 48 years. And recently, the two houses to the west of us were purchased by Chris. He's been he's taken good care of the property, no question about it. You know, he's got, but the property next to us can accommodate up to 16 people. So oftentimes, and my wife has photographs, and then the second home to the west is can accommodate, I'm not sure how many people, but. Okay. The one to the west, there's still cars parked there, there are trucks parked there. And we've got some photographs of that. U-Haul trucks, and so the one we're talking about there never seems to be a problem, I don't think. But the one we talk about in a minute is concerning us, and there are children in the block, and there are children that can ride their bicycles, but there's so many cars in the street sometimes that it's just not, it's dangerous. So anyway, the house to the west that we're talking about now seems to probably accommodate 2 cars in the driveway, okay? But there are cars in front of the street in the street too, and trucks, and U-Haul trucks, and trucks with trailers, people who have, are workers that bring their trailers with them. So I'm just concerned about that, and I wanted to bring it to your attention. And it's not a question of the quality of the property. It's not a question of how it's maintained. It's just that we've got some dangerous neighborhood, and we've got 4 or 5 people that are going to speak out about it. And we've never had that before. Also, directly across the street from the house next to us is a property that's been on the market for over 1.5 years. And it's been unoccupied, so they renovated it, and it's overpriced, but it's not sold. And that's the first time that property's been on, unoccupied since we've lived there 48 years. This is the longest it's ever been. So anyway, that's what I wanted to share.
Okay, thank you. George Gibson.
Well, I don't really have much to add other than this has become a real nuisance in our neighborhood. I have grandchildren that ride their bicycles in that area with cars parked on both sides of the street and up in the yard. We just do not need this in our neighborhood. Thank you.
You want to go ahead and respond? Mm-hmm.
I managed these properties for a little over a year now, and today is the first time that I've heard this. So I'm a little. I'm not arguing anything. I can't prove that that's not true. And obviously, they said they have photos. I have a great relationship with Mrs. Swift. I mean, I've got multiple messages from her of having family and people that want to be able to stay at our property, and we've had great discussions. I'm acknowledging what they're saying right now. I would say we're talking about 3308, which is not the next door property, which is a 3-bedroom property. It does have a driveway that would hold 5 or 6 cars, but we have never asked for that. So I don't know that. I really don't know what to add to it. I've never had a complaint before today that there was a parking issue for this property. That's all I got.
Okay. Questions, comments from the board?
Other than to add that I do have one complaint from Marcia from September a year ago that the next house, the music is too loud, and I drove over at 10:30 at night and resolved it. The letter that was read, I'm assuming, was in regards to this property. There's no sound.
It had both addresses on the letter.
Yeah.
Sorry?
It had both addresses on the letter.
There's no sound system to produce that sound, so I don't know what. And again, I manage other properties not in Oklahoma City, and I know the neighbors, and my phone number. I respond. I think they'll tell you that if they so. If there's a problem, I'm happy.
Do you own the property
I own both of these
and
two
manage them?
properties. Yes.
So you're the property manager?
I have a property management company that I do other properties as well. And it's a little thing, but 500 reviews and 4.98 average is pretty darn good. So from the guest side, obviously we take care of them. And if it's a parking issue, that's something that's typically not that difficult to resolve with better communication with guests and follow up.
Yeah, and on this property, on the application, you mentioned that the goal is to have these midterm rentals for insurance claims with families that have been displaced. I'm sure those are probably easier to deal with as far as the occupants when you have families move in.
That driveway will hold 6 cars. I've never had 6. Well, that I'm aware of. Maybe there's some photos that are out there, but I'm not. That's typical because it's a 3-bedroom property with 3 king-size beds, and so it's not a. That's usually 6 is typically the max occupancy. There is we converted the garage, so it's a real nice game room that has a queen-size bed. That's a pull-out sofa, so we've had 7 or 8 guests there. So just speaking on behalf of this house,
Do you remember what the maximum number of guests that we allowed in the original application?
I don't know what that original number was. I thought it was 8 because like I said, we have 3 full bedrooms that have king-size beds and a 2-bedroom, but it might have been 7 because you said 2 people don't want to sleep on a pull-out couch.
Yeah, which kind of one of our things is 2 per bedroom plus 1 if there is availability on another.
Completely understand.
This is a timely renewal also. No code violations, just the protests. So let's just go through for things we can do right now. The maximum number of vehicles, would you be good with 4 and no on-street parking? I know 5 could probably fit, it looks like from the picture.
Correct.
But if, I mean, that's 2 per car, get to 8. Do you want 5 or 4?
4 is,
okay.
4 is fine.
And no on-street parking. I think that seems to be one of the highlighted.
That's the theme.
Yeah.
I understand. And I will add, just for them, I mean, regardless of what you guys do, this house is going up for sale because it's too much money into this house. It honestly just it doesn't make any money. So we're going to be selling it.
Okay.
I'm a real estate agent, so I'm going to be listing it in the next 60 days. So
okay.
But it sounds
Good
like
to
the
know.
other issues with the other house too. So we'll talk about that in a second.
All right, and so quiet hours from 9 p.m. to 8 a.m.? Fine with that. So maximum number of guests would be good with 7?
That's fine.
And then the term? 3 years, consistent. Good?
That's fine.
3-year term? Okay. So for this one, I will make a motion to approve case number 15993 on the basis that it meets the statutory requirement for a special exception with the maximum number of guests to be 7, quiet hours from 9 p.m. to 8 a.m., maximum number of vehicles to be 4 with no on-street parking, and a term of 3 years.
I'll second.
Okay, we have a motion and a second. Cast your votes. Okay, this one's approved.
And I know it's approved, but I will make a commitment that there won't be an issue with, and my phone number is still available if there ever is.
Item number 35, case number 15994 is an application by Chris Cooper of Team Realty Investments LLC to allow home sharing at 3304 Rock Creek Road.
Chris Cooper, 6109 forgot where I live, 6109 Sudbury Drive, Oklahoma City. Application for renewal.
Okay. I got 3 signed up, same 3. Marcia, you go first then.
I'm Marcia Swift, 3300 West Rock Creek Road. And again, we're homeowners for 48 years. I might like to add that George has been a homeowner perpendicular to Rock Creek Road for 56 years. So we've seen a lot of changes. 48 years ago, we were the newlyweds on the block. Yesterday, we celebrated 48 years of marriage, and now we're the second oldest on the block. So we've been there quite a while. And so I want to make sure it's obvious. This block has 5 homes on it, 5 homes. So 2 of them are Airbnbs. And that's where our concern comes in. And I will, like Don said, Chris has been a great homeowner in regards to the care of the property. It's not Chris, it's just what goes on. And so I didn't enter these pictures because these things happened since Friday. And so this is the home across the street at 3305. And I do agree it's overpriced, but when a home's been on the market for well over a year, it's been updated. Our concern is it going to be another Airbnb?
I think that may have been resolved with the
new ordinance will not.
There's a
the new ordinance.
spacing limitation.
Okay, well, just real quick, because I do remember talking about this last year, and remember, it's per block, and they're in a
Right.
very small block. Their block is 108. So if they're referencing a house across the street,
it's the
that
other
would
block.
be a different block. So I don't want to answer that, but yeah.
Yeah, the one next door can.
So a home across the street's a different block?
Yes.
It's, yeah.
By the way, it was originally platted a long time ago, and
There's 2 homes on that side.
And that's the
there's
whole
3
block.
homes on our side.
These are your numbers here, this 108 that you're in, whoops.
Okay.
And then, sorry, to the north is block 107.
Okay.
Yeah.
All righty. So I just have a picture of last Friday, and July 11th, and I have had concerns about having company in for a bridal luncheon, and there was 3 U-Haul trucks on the driveway during the day. And then at night, they left and went to 7-Elevens to do work when 7-Elevens were not as busy. And so I explained to my sister-in-law, well, this is workers and whatever, that type of thing. And this home sleeps 16. And we've had school buses. We've had trucks pulling trailers that do repair on hail damage on cars. And they came from Texas, and I hope you know that I've never liked the Airbnb, but I've always tried to be neighborly and find out what's going on. And but they were there several times for the whole week with their trucks and all. And you can see here, this home does have an asphalt driveway where you can park, I think 5 cars or so, but that's not the issue. As you can see here, this was Thursday, July 10th, and this was, the cars in the street and that type of thing. So these are turnovers. This is the second time since last Friday. And then Monday, there were 12 cars for his property. And our concern is if you had an emergency, could an ambulance, could a fire engine get down that street? That's our concern. And then my last picture here was a car parked by the fire hydrant, and that obstructs, that type of thing. So at that property, one outlandish time we had I drove the neighborhood, and Chris was not the owner at the time, but it was over 90 cars on Spring Hollow, Brook Hollow, and there was a party going on, and my neighbor George and I were sitting on the front porch watching. They were clad in bathing suits and all kinds of things, and my neighbor down the street's little children, they were going, what's going on? And it was just, they were taking money at the door. We did finally, the owner lived next door, and they finally ended up with calling the police, but that was the extreme and that type of thing. So we just feel at times we live in a commercial, like a hotel. These things that are there not always are for residential people, but it's more business oftentimes. And so I smelt a lot more skunks around my property recently, and I feel like it's not always skunks. And I've seen that increase in smell when I go outside. And so we're a community for George's birthday, we had 26 people come to his party, and we're just love our neighborhood, and we support it, and just wanted to be safe, because with 3 turnovers of families and people coming in, you don't know who's there. And all of you board members, and I appreciate your time that you give to this, would you like to live next door to this? That's my bottom line question here. It's okay for others, and I know it brings in great tax dollars, and but we're just concerned about the safety and what's coming into our neighborhood, because we've seen a lot of changes in 48 years, and for George, 56. So I think that's about all I need to share. Thank you.
Okay. Thank you. Oh, the pictures, since you showed them to us, they go to Sarah, their evidence.
Okay.
Thank you.
Can I see them as well, please? Sure. I don't need a copy, I just.
Yeah, sure. And cars are going not the proper way. I had to, I could barely get to my mailbox on Monday because there was a car parked right by my mailbox. And those are just sad things that,
Sure, no, I get it.
and he doesn't always see this because he's, not there.
Yeah, I live 2 miles away, so I don't. Again, just like she mentioned, they just had a birthday party with 26 people at their house next door. This neighborhood, Quail Creek, is rear entry garages, and so there's a fair amount of street parking. We don't allow street parking. I didn't know there was street parking. I did actually know about this, and I'm there all the time because there's 2 houses. I drive by all the time. And I had to confront them to find out that, and I knew they were there for a funeral. I didn't know that their plan was this was going to be the come and go stop for the family, was because they were in town for a funeral. And so I hadn't seen this, but I just want to see the pictures for the dates on them, and I was looking at my calendar to verify the dates. So 100% that did happen. I did address it. It's happened in the past. I wish there would have been a little, well, I'm making excuses. When I'm aware of a problem, we address it. And other than Marcia did ask me for a contractor for French drains, and I haven't responded to her yet because I haven't found one yet. And so, but we do address problems when they come up. And so I'm sorry that you've had this experience with vehicles.
And they had made mention that the house let 16 or whatever this application is requesting a maximum of 10.
It's a big, I mean, it's a 4-bedroom house that's effectively a 6-bedroom because of some bonus rooms. I've got, there are 9 beds in it, but obviously there's not, I don't know that I've ever, when you count bunk beds, because sometimes it's 3 or 4 couples and sometimes it's 2 families with a bunch of kids.
And it has a swimming pool that can add to the complications of running a short-term lease.
But I am the one that deals with it. I mean, I'm there. I don't clean the houses, but I do take care of the pool because that's my background. And so I'm there. When someone stays, like I've got a guest right now that's there for 18 days, I'll be there twice a week just checking the pool chemicals and the water and things like that. So, but I'm certainly hear the concerns. But today is the first time I've heard them.
Okay.
Still got 2 signed up.
Oh.
Don, do you want to add anything? And George?
Do you guys want to speak again?
I'm having real trouble hearing you today, so help me.
We just asked if you want to add anything to the protest for this property.
Sorry, tell me again.
We're at 3304 Rock Creek is the house we're talking about. And you signed up to speak on this application.
Yes, I think so. Thank you.
Okay. Don?
Again, Don Swift, 3300 Rock Creek Road. My only concern is that on the weekends, kids are out of school. We've got several kids on our adjacent street that turns into Rock Creek Road that are on their bicycles, okay? And people are parking in front of our house on the weekends when they have big crowds next door at this home that can accommodate 16 people. And they're on the street. It's not unusual on the weekends to see those pictures like you see, okay? And so that just doesn't make sense to me. And Chris, it's not his fault, in my opinion, but we've had that property with the previous owner that had it, and there was a party there that had to be, kids came out of nowhere for graduation, and they had to haul them off. The police hauled them off. So that's a big house. It's got a swimming pool in the backyard. It's real attractive, and Chris has done a nice job of making it even more attractive. So, but that's our neighborhood. And that's where every weekend we see cars in the driveway, in that circle driveway, in the driveway. There's no garage, and cars parked on the street, and people are coming and going. So that's just our concern. And
Okay, and I want you to know that I'm going to limit the number of vehicles and not allow any street parking. So if there's street parking, you need to call the City Action Center right away and have them come out, and they will file a complaint.
We can call Chris.
Or you can call him, and I'm sure he's going to notify every applicant or every one of his renters to not park in the street. I think that's one of the biggest issues.
We don't like to be here Chris is a good guy. He's a good homeowner.
And I want you to know that the application is not asking for 16 people. The maximum number of people that can be in that home will be 9 or 10. That's it.
I don't know that there's always been 16, it's just that when
No,
you go to the website, want to rent the place, it's getting rented up to 16 people.
It was a party place before we bought it.
Yeah,
Yeah.
and it was.
Right. And I think his object is, again, to have midterm rentals with families and who are displaced by insurance claims.
Well, no, I want to thank you for taking a look at this.
Thank you.
Okay, I think we just get to the application. And so this is a renewal, it's timely, a term of 3 years. Number of vehicles, you can park 6 easy. And no on-street parking. Quiet hours from 9 p.m. to 8 a.m.
Okay.
And then, I don't know what we did the last time on the number of people, but I would like to see it to say 9, with just 4 per bedroom plus the 1.
Okay.
I think
It's a 6-bedroom, but I understand what you're saying.
I get
Okay.
it. Well, I think, is it a 5-bedroom? It says 4 on the application, but I just want to make sure.
There's 9 beds, but yeah,
I think it's a 5-bedroom house, though.
it's a 5-bedroom house with a converted game room.
Right.
That
So-
has beds, but I understand.
I'll give you 10, because I think it is a 5-bedroom home.
Okay.
Just by,
Sure.
I grew up in this house, not this actual house.
You know,
but
all those
that
houses in Quail
design
Creek, I
Quail
live
Creek.
there too. They're all 4 bedrooms upstairs, but
Right.
now downstairs has a big converted
Yeah,
bedroom.
so, anyways,
We'll take it.
okay, 10.
Okay, is there anybody else who wants to address the board on this application? Ready for a motion?
Yes. So I'd like to make a motion to approve case number 15994 on the basis that it meets the statutory requirement for a special exception, maximum number of guests to be 10, quiet hours from 9 p.m. to 8 a.m., maximum number of vehicles to be 6, no on-street parking for a term of 3 years.
I'll second.
Motion and a second. Cast your votes.
I know we voted, but I just want clarification. Is it being advertised as 4 bedrooms or 5 bedrooms?
The application said 4, but I believe it is a 5-bedroom. I don't know what the
I just wanted us to be
advertisement is.
consistent,
Right.
because we will get called on it. in
Yeah,
terms
it's
of
a
the number of-
5-bedroom home.
I'll make sure that everything
Plus
marketing
one.
says that. I was just pulling everything off straight off the county records, which says 4 bedrooms, so I didn't, that's what we had, that's what it was listed as. And that's when it was, when I bought it. Like I said, they've seen it. We made a nice big downstairs because for elderly folks that didn't want to have to go upstairs. And so if I go to sell it, that's going to be listed as a 4-bedroom house, but it's, for purposes of a short-term rental, it's a 5-bedroom property.
Okay, thank you. I just wanted there to be consistency in
Yes, ma'am.
terms of how we rule on things.
Yep.
Thank you.
You're good. It passed.
Yep. You're approved. Pardon?
I have one more.
Yeah, you're up again.
Lucky you.
Case number 15992 is an application by Chris Cooper on behalf of Agape Ventures Group LLC to allow home sharing, 2809 Pembroke Terrace.
Nobody signed up on this one. Does anybody want to address the board on this application? Okay, go ahead.
Chris Cooper, 6109 Sudbury Drive, Oklahoma City. This is a property that is currently for sale, not, I manage this for somebody else, and I'm trying to help them keep it from going to foreclosure, so we're managing it as a short-term rental while they have this property listed, trying to get it sold. It is a 4-bedroom, it's a 3-bedroom home. It has an attached by a 3-foot breezeway guest quarters, so it's a 4-bedroom home, 2 kitchens, 3 full baths.
The application says maximum number of guests 3.
Yeah, I thought you
I can
wanted
go
to-
higher
That's a
than that.
mistake. 'Cause
I can go higher.
It's four full bedroom, and it has, the guest house has a bedroom with a queen bed, and it has a, because it's like a, what do you call it? Like an apartment that's just one big room.
Studio?
It's like a studio, and it's got a queen-size Murphy bed, but then it has also a bedroom with a queen-size bed. So there's 4 bedrooms and the queen Murphy bed in the studio. Golly, I wrote 3. I didn't know.
Did anyone sign up on this?
Nobody signed up on this one. Does anybody want to address the board? Okay.
So, just through the application, the 4 bedrooms, maximum number of guests, 8?
Can I have 9 just because I have 4 full bedrooms and a queen-size Murphy bed? I don't know that I've ever had them. I just don't want to miss out if that's.
I can go with 9.
That's consistent. Quiet hours, 9 p.m. to 8 a.m. Maximum number of vehicles to be 4 with no on-street parking, and the term's gonna be 1 year.
1 year?
Yeah, it's late. It says late. Let's see how late. Yeah, it's a little over a month late.
So that's going to cost me 2 years. Okay. Just because I didn't have a June meeting, so I didn't know that. I didn't know how the process worked until I got letters saying that the actual license
And
was
really, it's
expiring.
the date the application was filed, so if whether the meeting happened or
No,
not,
I
it was
get
the
it.
application. And if it had been 29 days, we'd have given it.
I think we're ready for a motion.
Okay. With that, I'll make a motion to approve case number 15992 on the basis that it meets the statutory requirement for a special exception with a maximum number of guests to be 9, quiet hours from 9 p.m. to 8 a.m., maximum number of vehicles to be 4 with no on-street parking for a term of 1 year.
I'll second.
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you for your time.
Item number 37, case number 16000 is a special exception by Soul Properties LLC to allow home sharing at 9828 Hefner Village Drive.
Hello, my name is Maribel Wilson. I'm here for 9828 Hefner Village Drive, and I'm here basically for the special exception of the home sharing.
Okay. Nobody signed up on this one, but there were some protests in the packet. Okay, does anybody want to speak on this application? Okay, your turn.
Pardon me? He's my neighbor, but we came separately. My name's Ron Frick. I'm a resident of Hefner Village Drive. I live at 9818. My wife and I have been there 7 years. After we sold the farm, we was on for 25 years. We really have a unique neighborhood. This corner is amazing, and I am 58 years old. We moved there because of my health issues. I guess our concerns is not knowing who our neighbors are. We've lost 2 neighbors, I believe, this year. Our street there is a private street. It has no curbs. It's hard to get EMS down them streets if there's those that park on the streets that's not allowed to, but end up, we have that. I mean, it's a neighborhood where if there's a red Tahoe not across from me, I know Connie's not there, and I need to know why in the wide world of sports she ain't there. And so I go bang on the door and find out where Connie's at. It's a neighborhood where Mary and Larry across the street, my wife and I, we go to dinner with them at least once a month just to get them out of their house. Jim McKay, we know on Friday nights at 6 o'clock, you better be there for toddy time because he'll start without you. Mark is a neighbor down the road that if I need somebody to come to my house to let somebody in, he'll let them in, but he'll bird dog them the whole time they're there. If he don't know their name, social security number, where they live, I'm surprised because that dude's on it. That's the kind of neighborhood we have. To have an Airbnb move in, we're concerned about that. We know everybody that pretty much goes up and down that road, and that's the reason why we moved there. Our concern, I believe, is genuine. It's just for security purposes. Joy, my neighbor that'd be close to this residence that's going in, she's 94 years old. She don't need to be hearing all that noise going on. If it does happen, I don't know that it would, but I'm just saying. Well, I don't want to take the chance. I don't want to lose another neighbor. I just lost Joe, and I don't want to lose another. Just not to nonsense that don't need to go on. That's the reason why I'm here, and that's the reason why I'm talking. I appreciate it.
Okay. Did you want to speak?
Thank you. My name is James Carroll, and I'm one of the neighbors there on Hefner Village Drive. Also, I've lived there for about 15 years now. A little quick history on Hefner Village. We're 70 buildings out there. We have 236 families. The main road that goes through there is Hefner Village Boulevard. We have 5 streets that feed off of the boulevard, and they're private streets. They're classified as fire zones. They're narrow. There is no street parking in there. So that's a major, major issue with us. And when we have these Airbnbs come in, it's all well and good to say that you can't park in the street, but they do. And then the fire truck can't get through. And I know I had an incident. I had an accident and I broke my neck. And fortunately, they could get to me in there. So when we see people come in like this, and I haven't seen yet how many guests that they're going to have or how many parking places. It's not up here. Can you put that up?
Oh, I can tell you. They're requesting a maximum of 6 guests, and then we'll discuss the parking. It's not listed.
Yeah, it's 2 bedrooms, 1,500 feet in there. Mm-hmm. So, and that's the main issue. And there's no sidewalks. Everybody walks in the street in there. They talk about, well, they have some additional parking. That's guest parking. That's not for Airbnbs. That's for grandma when she comes over to see somebody, or the kids come over to see grandma in there. It's called guest parking. It's not resident parking in there. So anyway, it's a close-knit group out there, and our area is limited. Again, back on the streets of fire zone, this is about halfway down. In the streets where the fire zones are. So anyway, any questions of me? I used to be the president of the HOA. I believe you folks received a letter from the HOA. Our attorney is also involved. It is against our bylaws.
We did receive the letter from the HOA in the packet, and a couple of protests along with a copy of the CC&Rs, and I believe they're new CC&Rs because they were adopted on June 20 and 25. Well, do you know if these have been docked?
The best way I can answer that, and I can go back to 2014 when I moved there. We've always had it in there that you can't run a business in Hefner Village, period. It's been there forever since '74 when they were incorporated. They have cleaned the language up, because you can play with the words if you like in there. So that's what you're looking at now, is the cleanup of the language that we went through the attorney to get the legalese put in there. So it's always been that way. There's been no changes on it.
When was this application filed?
Cindy will check that, but I don't think that portion of the ordinance depends on the filing date.
Just curious.
But it was filed under the new ordinance.
Yeah.
Yes.
And we can use the CC&Rs to help make it our decision. I just think that I wanted to make sure or see what you knew about the new rewrite that seems to be approved on June 18th by the board. But my understanding would be that the entire neighborhood would have to vote 100% to approve these.
Sorry, 100%, yes. I'm not on the board any longer, so you may ask me questions here I can't answer, but I do know in speaking to the current president over there that, yes, that they did run it back through the attorney. This has been in the works for a while because there's always a question about it, isn't there? It didn't specifically say this.
Well, when you first wrote the CCNRs for Hefner Village, short-term rentals didn't exist, so it'd be really hard to put that terminology in. I just was kind of wondering.
June 5.
I guess,
Okay.
yeah, Mary Irvine signed them and a Hillary Snyder.
Mary Irvin, yeah, she's the president of the current board.
Mr. Voorhees, it's on the application, it says I submitted it June 5th.
Okay, thank you.
And I remember from a previous application that at Hefner Village that they did mention the CCRs did not allow businesses to be
Right.
the typical wording that we see in a CCNR.
Can I go ahead? Okay.
Go ahead.
So I wish I could have responded to them individually. I totally understand where they're coming from when it comes to making sure that the neighborhood is safe. I feel like currently what I do is that I specify you are not to park in guest parking if you have, because there's people that come from out of town and they're like, hey, I'm gonna have this person, come over for 3 hours. Is that okay? I always say, yes, that's okay. There's guest parking for them if they don't fit in the driveway, but they are not allowed to park for longer than a certain period of time. They're not allowed to park on the street, all those things. So I sympathize with those things and trying to keep the neighborhood safe. I do have cameras that face the side of the house, the front of the house, the doorbell, not necessarily the backyard, but towards the side of the backyard, so I can always see like who's walking, who's parking, if they're on the street, all those things. When it comes to the HOA bylaws, that's currently kind of up in the air because so I have an attorney and the HOA has an attorney, along with some other Airbnbs that are short-term rentals there that were pre-existing before they decided to change this. Sorry, I'm kind of getting I get nervous. I'm not a public speaker. And so they decided to change these rules when there were already existing short-term rentals. And so the argument that the attorney is having is, one, they are violating changes and saying there's no short-term rentals allowed, but legally it's not really binded. And so we're kind of in the works with that still. The attorney has said you can keep renting until things go to court and it's finalized. Another thing also is that he's trying to work with them to get the current short-term rentals to be grandfathered in. So, but from there on, whoever comes in they can say no, absolutely not anymore. So we're kind of in the works on that, but as of right now, the HOA hasn't really voted, or basically the attorney is stating, and I don't know all that legality, all that verbiage, but he's basically stating you are still allowed to rent, all the short-term rentals there are still allowed to rent until I tell you otherwise, because really it's not whatever they call the legality of it. Does that make sense?
Yeah,
I don't know.
that's understood.
Yep.
Are you operating this as short-term rental right now?
I am. I started operating in March. I was not aware that I had to get a license, and I know that probably sounds odd, but I was not. And so as soon as the attorney said, you have to do this, I immediately applied, which was right around the time that the HOA made changes. Also, I would like to, just for their peace of mind, I do like them to know that anytime anybody checks into my Airbnb, I watch the doorbell on how many people are coming in. I watch how many people are parking. I watch it at 11. I watch it at 2. I probably don't sleep. Because I am so respectful of the neighbors. And there is an older lady that lives in front, and we've talked, and I promised her, I said, I'm gonna make sure that everything is okay. We can't control it all, but I can try my best. I think that's it. If
So
guys
you
have
own the
questions.
property
Yes,
and you're managing it?
yes.
Do you own any other short-term rentals in Hefner Village?
Not in Hefner Village, no. I'm currently remodeling one that's more in Nichols Hills, yeah. So this is my first.
I think there's 2 others in Hefner Village that I found also that are operating. Marcus.
Yeah, I mean, I understand the sentiment or the idea that the CCRs preclude any business activity, but I believe that the discussion that we all had whenever we sought to gain clarity and consistency in applying this, which was taken into consideration in the code update, specifically dealt with the CCRs expressly stating that short-term rentals were not allowed. And the CCRs that are before us now do expressly state that. However, as Board Member Noble has pointed out, they have a date of June 18th, which is subsequent to the application date. And so for me, I think it's pretty simple. Had the application been filed after that, this would be subject to that. So, I mean, staff, correct me if I'm misunderstanding some of this, but.
I don't actually totally agree about the filing deadline or the filing date. However, in the board's consideration regarding this item, which is item I on page 3 of your staff report, there's actually 2 conditions, and one is that the CCR specifically identify home sharing as short-term rental, which I believe they do. But then the second is that those are filed, that's filed of record against the real property on which these would occur. And that's not something that that staff can confirm for you today. I will note that this is, I don't believe you've ever had this happen where under the new ordinance where this actually applies to a new application. In this case, it does. If it is granted today and next time it comes back as a timely renewal, then this would not be one of the considerations for a renewal. So I hope that makes sense, what I just said.
I think so. So
I will say also, I'm showing you their subdivision on the map here, and each of those is a block. So this is a neighborhood where for every 3 homes, you could technically have 1 special exception home sharing application.
So the conditions to be able to consider the covenants and restrictions are that they both expressly state that short-term rentals are not allowed and they be filed of record.
Yes, this is new territory for us because typically these are not part of your consideration, but under this new ordinance effective last year, just for the record, Chapter 59, Section 9350.38.1, which are the specific standards for home sharing, includes item I, which is your ability to consider as a basis for denial any restrictive covenant that both specifically identifies home sharing in the covenants and restrictions and is also filed on of record against the property in which this use would occur.
And then you're also saying that if we were to grant this today, it would basically grandfather it in against if these ever got filed.
If, for this property, if it was granted today and continue to be a timely renewal,
Right.
meaning that the application for your next special exception was received and accepted prior to the expiration date of one that may be granted today, then there are several conditions in this section that don't apply to timely renewals.
Okay.
Okay. And I'll just say, and for the record, I guess, that when we have an operator that's operating illegally, that in the past I have made them defer for the number of months between then and now to then come back to reapply without operating illegally. I just want to know what my fellow board members think about that restriction that we've done in the past.
I don't have a problem with it.
When there was protests. When there wasn't protests and they were operating it okay, we didn't do that. But when there
And
was protests, that's something that we've done in the past.
And I truly do apologize for that. Like, I was not aware, ridiculously enough, but I mean, it was my first time and I just was not aware of the steps that I had to take.
Okay, well, wait a minute, clarify something. I think I asked you that did you have any other short-term rentals? And did you say that you did? That
No.
you do?
No, I have one that I'm remodeling.
You have one that you're remodeling?
Yes, so
Thank you
it's
for
not, I haven't
clarifying.
even
Okay,
did it, done, I haven't, I mean, it's not even remodeled.
okay.
Yeah,
Thank you for clarifying.
yeah.
Okay. Any other questions, comments?
No, I mean, I think I can be in favor of the application. I think that I'd like to go through the application and just, the term would be for 1 year.
Okay,
2 cars, no on-street parking. Quiet hours 9 p.m. to 8 a.m. And then the maximum number of guests. It's a 2-bedroom.
it's a 2-bedroom, 2.5 bath, yes.
How do you sleep 6?
Usually an air mattress.
So,
But I'm okay with 5, just because sometimes they'll bring a little kid with them, a
Right.
couple. I did want to ask on the parking. I mean, you can fit 2 cars in the parking in the garage. Most of the time, they only do 1.
Is the garage available?
Yes.
If the garage is available,
Yes.
I'll go more.
Yeah, I mean,
You
most
can
of
put
the
2
time.
in the drive and 2 in the garage.
Huh?
2 in the drive, 2 in the garage.
Yes, yes.
So that works. But I'm going to
Thank you.
state that too. So you can't park on the street.
Right, yes.
Yeah, that means you can park in the parking lots. A
No,
legal
I'm so
spot is.
specific with
I
my
know,
rules.
but I'm just saying that a legal spot that's for parking is for parking.
Yeah.
I'm just saying no street parking. You have a lot of people, a lot of eyes on you. I mean, you'll operate a good business, I know.
Yes.
So 5 guests,
Yeah.
good.
Right.
I'll let the lawyers talk for a little bit. It's 6:02, we can talk about anything we want.
I didn't realize this took this long.
It doesn't usually.
The last person.
It's all right. Could have been worse. There's 2 that are pushed and there's 20 deferrals.
20 that didn't get heard today.
Yeah.
Okay, can I just ask one question? And I don't know if this is inappropriate to ask you guys or the office, but I don't want to be late on my renewal, so would my renewal be the meeting day or the application day of the renewal?
It's the application, but
The
you want to
application
start
day.
a couple
Okay.
of months early.
Application date, Sarah Welch, Planning Department. I realize I didn't say that earlier. I also want to say that, as stated before, we have not, this item, this section of the code has not come up before, and I'm rereading it, and I apologize, everyone. But the section of this code that talks about the covenants and restrictions, it says that provided the subsection shall not prevent the timely renewal of any home share or short-term rental special exception that was lawfully issued to the operator of the home sharing short-term rental accommodation prior to the effective date of the ordinance. So I am very sorry about that, because this ordinance was adopted in 2024. So I need to retract what I said. When you come back in a year, if you're approved today and the covenants are passed and they are applied to your property, that actually is a basis that the board could consider a year from now. I'm very, very sorry.
That's okay, I'm confused anyway, but.
Okay.
So if your neighborhood changes your CCNRs
Yes.
and they do not allow, then we will be able to use that as a reason to deny.
Even though it was done after the time of application?
Because the ordinance states.
Okay,
so.
so the ordinance was done in
Right,
2024?
yes,
Okay,
I'm so
okay.
sorry, because in most cases, a timely renewal exempts you from many things. This one specifically says, prior to the effective date of this ordinance, meaning the changes that were approved by city council in 2024.
Okay.
So
In
I
Oklahoma,
apologize.
CCNR changes take 100% of the neighborhood to
Yes,
jog, so-
that's what we were talking about.
Yeah.
Okay.
Okay. You ready for a motion?
Definitely.
We're in the 16,000s. I'll make a motion to approve case number 16000 on the basis that it meets the statutory requirement for a special exception. Maximum number of guests to be 5. Quiet hours from 9 p.m. to 8 a.m. Maximum number of vehicles to be 4. No on-street parking and for a term of 1 year.
Thank you so much.
I'll second.
Okay.
Thank you.
You're almost there. We got a motion and a second.
Okay.
Hang on, cast your votes. Now you're approved.
Okay, thank you. You guys have a good afternoon.
Well, it's evening.
So now we're going to go back to item number 12, case number 15817. Special
1 year.
exception by Mr. Doan for our home sharing at 9317 Northwest 118th Terrace.
We want to continue it to
Yeah.
August 7th, so he didn't.
August 7th?
August 7th?
Okay.
Okay.
We'll make a motion to continue case number 15817 to August 7th.
I'll second.
Okay, motion and a second to continue. Cast your votes. That one's continued.
Then we have item number 33, case number 15991 for Bryce Louders to allow home sharing, 2319 Northwest 17th Street.
I vote we continue that one to August 7th.
I'll make a motion to continue case number 15991 to August 7th.
I'll second.
Okay, we have a motion and a second. Cast your votes. That one's deferred. And I think we continued or got a withdrawal on everything else.
To the end, yes, sir.
So we're down to additional items, please. No additional items. No board committees. I don't have anything to add. Does anybody else want to talk?
Can I please say something very fast? Just one update. Since your last meeting, the city council approved increases to some of our fees, 2 of which apply to this board. Well, 3 technically. One is that the appeal to an administrative decision will increase to $1,450. And then the other one that's affected is the home sharing. If you might remember, new applications were proposed to be the same as a regular special exception, which is $1,100. At council, there was an amendment made that allows timely renewal applications to be $750. So those changes go into effect tomorrow for applications received starting tomorrow. And then the other thing is that you will start to see, not your next meeting, but the one after that, a little bit different application submittal from applicants. We hope it'll be more streamlined, more communicative to the applicant and easier for you to administer as you're reviewing these on a case-by-case basis. And then the final thing is that thank you all for this long, long day at 6:08 p.m., especially Mr. Don Noble, who graced us with his presence on his birthday.
Oh, happy birthday.
So, happy birthday, Mr. Noble.
Okay.
Is that a gift that we don't say?
Okay, Rita, you want to talk? I don't see any citizens to be heard. Does anybody have other business? I vote we adjourn.